Your lawsuit, I beg to seek a lawsuit permission for a matter to be listed on orders, my lord. AMFA, my lord, is a widow's case. It was in the hearing list twice.
MFA a separate court,
My lord,
court number 19.
Right, Mr. Lordship. In item number 12, I have filed a written objection against the bill. Can I be permitted to bring it on the record?
Yes.
May I please, your lordship?
Well-
My lord, I beg to mention for listing of an urgent matter for tomorrow for motion, my lord.
What matter?
As the matter is pertains to the eviction of the petitioner for the subject
What
land.
matter?
It is a CRP matter, my lord.
Okay.
Civil eviction petition, my lord. As
When have you
tomorrow, my lord.
filed?
Today, my lord.
Have you filed or no?
Yes, we have in the process. It is in the process, my lord.
No, after filing you have to mention.
My-
Not before.
The filing number, my lord.
Have you filed it or not? Or you
Yes,
have?
Yes,
Yeah.
file.
Okay, tomorrow.
Yes. Yes, my lord. We filed today.
You have not yet filed.
It has filed. We have got the filing number, my lord.
You have received filing number.
Yes.
Okay, tomorrow.
Yes. Oblige, my lord.
I am paying for listing of IA, my lord, to as my substitution, my lord, in CRP matter, my lord. The next week, my lord, if it is possible on 23,
Next week is motion week.
23 I am for orders only.
Okay, 23.
23. Obligement.
May I please, Lordship? In item number 31, kindly pass over the matter, Lordship. My senior is out of station, Lordship.
Have you informed the other side?
No other side, Lordship. Private trust,
What is your name?
S.A. Islam,
Mr. S.A. Islam. Learned
behalf of N. Ahmed.
learned counsel for the applicant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the applicant. The prayer is allowed. Let this matter be listed. 27 July.
May it please your lordship. Lordship, I'd like to mention item number 26, lordship. Lordship, I am praying for adjournment, lordship, as senior counsel is out of stations.
Have you informed the other
Yes.
side? Heard, Miss, what is her name?
J. Bezura, lordship.
J. Pejura, learned counsel for the applicant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the applicant. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Stop. Hence, the prayer is allowed. Let this matter be listed. 29th of July.
Yes, please. I beg to mention item number 27. With the consent of the other side, this matter may be taken up after vacation because the conducting counsel is undergoing treatment.
Heard, Mr.
Peace over.
P. Chaudhary. B.
On behalf of each other.
You are P.
Yes.
Heard, Mr. P. Chaudhary, learned counsel for the respondent who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. He submits that he has informed learned counsel for the applicant regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed. 29th of July.
Yeah, please, your lordship. Lordship, in item number 15, I have filed an additional affidavit, my lord, that may be called. Filed.
I beg to mention item number 42, the hearing. On 29th May of 26, the Honorable Court had directed us to give the name and address of the legal heirs of
Item number 40?
42. Lordship.
Yes.
Lordship, I am for the appeal and lot. The respondent, sole respondent is died. That was informed by the council, Lordship, on 29/5/2026. We have to directed to furnish the
Name and
details of
address.
the
Legal heirs of
legal sides of the case.
We already filed. We will give them.
You have
Today, Lordship. That
You
will
have
be-
furnished the names.
Yes.
You will be requiring some time to take steps. Heard, Mr. What is your name?
And Thakuria for S. Sir.
And Thakuria, appearing for
That's one.
the respondent. Also heard Mr.
Das.
M. Das, learned counsel for the appellant. It is submitted at bar that the names of the legal heirs of deceased respondent, deceased respondent has been furnished to the learned counsel for the appellant today only. Hence, some time is prayed for taking appropriate steps for substituting the legal heirs of the deceased respondent. The prayer is allowed. Let this matter be listed. No, after 4 weeks on a date to be fixed by registry.
May I please, Your Lordship? I beg to mention an item of RSA matter for hearing,
For listing,
for listing.
listing, hearing will not be by mention.
As the-
Hearing,
As in
hey.
this matter, appellant is already called for.
hearing you pray before registry. Pray before registry.
It pleases your lordship, I beg to mention item number 11, madam. But it ought to have been fixed on 17th of July, madam. Item number 11,
Any fixed date was given?
fixed 17th of July, madam.
Stop. Heard Mr. B.D. Deka. You are not B.D. Deka.
I am A Deka, madam.
Heard Mr. A. Deka, learned counsel for the petitioner. Also heard Mr. G. Bhardwaj, learned counsel for the respondent. It is submitted at bar that this matter was directed to be listed on 17th of July. However, it has been listed today wrongly. Stop. Registry to list it on the fixed date, that is 17th of July. The interim shall continue. Interim was earlier directed to interim order shall continue till next day.
May I please, Your Lordship? Lordship, I beg to mention for listing on CRP IO, Lordship.
Or
For admission, Lordship. Lordship, next week, some urgency is there, Lordship.
what urgency?
Lordship, execution proceedings are going on and the respondents, they are trying to forfeit the.
Due. 23rd June.
May I please, Your Lordship? My lord, I beg to mention item number 47, my lord. My lord, may I pray for upgradation, my lord, after motion? Because, my lord, execution proceeding is going on. Item 47.
No upgradation. We will take it up today. Today we will ensure that it is taken up.
May it please your lordship. Lordship, I beg to mention a listing of a second appeal for admission, lordship. It was
22nd July.
Please, Lordship, I beg to mention for listing in admission club and CRPI.
22nd July.
My lord, the petitioners agreed with the impugned order dated 6 December 25, passed in the title appeal number 9 of 2019, passed by the learned civil judge senior division Kamrup Amilga. Operative portion of the impugned judgment and order of the learned civil judge is lordship will find at page 101 of this revision petition.
You have filed additional affidavit.
We have filed additional affidavit, but that was even not considered at the time of final disposal.
No. By this court on last day, you were directed to file an.
Yes. I have placed on record the additional affidavit, the decree of the passed by the learned appellate court.
Okay, which page?
Additional,
Impugned judgment,
Annexer 10, my lord.
page number?
88 to 118. Operative portion of challenge 101.
What was decreed?
Case is, my lord, the learned trial court decreed the suit in favor of the plaintiff by holding that I am defaulter in payment of rent. But the cause of action of the case was something different, my lord. A notice was served upon the defendant, who is the petitioner before your lordship, that for renovation of the suit premise. But the suit has been filed by the plaintiff for default of rent. That is one side of challenge. That apart, my lord, the present petitioner had filed some NG case to deposit the area rents in favor of the plaintiff, in the name of plaintiff. But that has not been considered also, neither by the learned trial court nor by the appellate court. And despite a specific direction of this honorable court, which your lordship will find at page 86, my lord, with regard to 86, my lord, para number 7, my lord. May I read out?
The trial court decreed your
Trial court decreed in favor of the plaintiff, who is
for
the
your eviction,
for eviction,
and the
And the-
appellate court upheld the judgment.
upheld the judgment.
What is the wrong in the appellate courts?
There are so many wrongs because the cause of action was not dealt with by the learned trial court in proper sense. Very casually dealt with issue number 1. That apart, my lord, the present petitioner tried to apprise the learned appellate court with regard to deposit of NJ case rent challenge. That has not been also considered, despite direction of this honorable court passed in CRPIO number 28 of 24.
Heard Mr. S. Paul, learned counsel, heard Mr. A. Paul, learned counsel for the petitioner. This revision and petition under section 115 of the Code of Civil Procedure has been filed by the petitioner Papu Kalita, impugning the judgment and decree dated 6/12/2025 by the Court of Learned Civil Justice Senior Division, Kamrup, Amingaon, in title appeal number 9/2019, whereby the judgment of the trial court dated 1/3/2019 passed by the Court of Learned Munsif Rangya was upheld, and the appeal was passed by the trial court of Munsif Rangya in title suit number 10/2014 was upheld, and the said decree was and the appeal was dismissed. By the judgment of the appellate court, the eviction decree has been passed against the present petitioner. Stop. I have gone through the grounds taken in the instant civil revision petition. Issue notice to the respondent and call for the records of the trial court as well as first appellate court. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of August. Let the registry shall take steps for requisitioning the records list accordingly.
In the meantime, my lord, input order may kindly be stated.
Whether any execution case has
Yes,
been
yes,
filed,
so far as instruction, they have filed execution.
what is the number?
Number I do not know, but
You
we have
file
not-
you file an I specifying the number of the.
My lord, in similar circumstances, in another case, my lord, a coordinate bench already state the similar input order passed in different case. Against same
No,
opposite.
you answer to the query posed by the court. If an execution case has been filed, you give the details of the execution case. I will stay it immediately.
today I cannot.
You come to the court with the number, we will stay, but not now. Unless an execution case has been filed,
So far as instruction, execution has been filed, but the details I have no idea.
take details, then we will give you relief.
Is there any requirement of filing interlocutory application?
That you decide.
Obliged.
May I please, His Lordship?
Yes.
Lordship, the petitioner is praying for transfer of a title suit, Lordship, filed by the respondent for dissolution of marriage from Learned District Judge to Learned District Judge Bongaigaon, Lordship. On the ground, Lordship, the petitioner is
Where to where?
from Jorhat to Bongaigaon. Lordship, the petitioner is presently staying in her matrimonial mother house at Bongaigaon, Lordship. And the distance between Bongaigaon and Jorhat is about 500 kilometer, Lordship. She has no income and she has a 10 years old school-going child.
Heard, Miss, what is your name?
Bidas.
Heard Miss Bidas.
The further proceeding may stay, Lordship.
Heard Miss Bidas, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Srimati Sagarika Sakya, praying for transfer of title suit within bracket M, case number 25/2026 from the Court of London District Judge Jorhat to the Court of London District Judge Bongaigaon. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of August. In the meanwhile, considering the averments made in the instant petition, as well as considering the submissions made by learned counsel for the petitioner, further proceeding of title suit M, case number 25/2026, shall remain stayed till next returnable day.
Same matter, Lordship. This is for guardianship of the minor child, Lordship.
Where it is pending? Same, Jorhat.
Yes, Lordship. Jorhat to Bongaigaon
Where is the son now?
with mother, Lordship.
Where?
Bongaigaon.
Bongaigaon. Okay. Namely, this application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Sagarika Sakya, praying for transfer of misguardianship case number 2/2026 from the Court of London District Judge Jorhat to the Court of London District Judge Bongaigaon. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days, same day. Learned counsel for the petitioner submits that the minor is presently staying with his mother at Bongaigaon. Hence, further proceeding of missed guardianship case number 2/2026 shall remain stayed till next returnable day. List according.
This is also a transfer petition, my lord, for transferring of the divershood filed by the husband at Shivsagar to be transferred to the Court of Learned Court of Tinsukia, my lord. The petitioner is the resident of my lord Dhola.
Your wife,
my lord.
your wife,
Yes, ma'am.
what she does?
She's at Dhola, my lord.
She's a housewife or?
No. She's running a private school. My lord. Aged is 58 years, my lord.
58 years.
My lord.
Now, what is the difficulty to?
Difficulty inconvenience, my lord. Earlier, all the cases filed between the parties were filed at Tinsukia,
Okay, there are other cases also.
my lord. Maintenance and other cases were filed at Tinsukia.
Or Mr. A.K. Maheshwari, the learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure has been filed by the petitioner Srimati Rupushri Kalita Datta, praying for transfer of title suit matrimonial number 35/2026 from the Court of Learned District Judge Tinsukia, from the Court of Learned District Judge Shivsagar to the Court of Learned District Judge Tinsukia. Learned counsel for the petitioner has submitted that there were other cases pending between the
Not
parties.
pending, my lord. Please vote.
There were other cases which were filed by the same parties, and they were filed in the Tinsukia, in the courts at Tinsukia. It is further submitted that the petitioner is a lady of 58 years of age. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this, returnable on 5th of August. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, further proceedings of titles of matrimonial number 35/2026 pending before the Court of Learned Additional District Judge Sipsagar shall remain stayed till next returnable day.
Item 6.
Your Lordship, the petitioner being judgment debtor filed an appeal, money appeal in the lower appellate court, Your Lordship, along with a condonation petition for condoning the delay of 764 days, Your Lordship. That condonation petition was dismissed by Indian order dated 17/6/2023, Your Lordship. 17/6, annexation number 8, Your Lordship, kindly see page number 58.
Then whether revision is maintainable.
Your Lordship,
Appellate court dismissed the
condonation petition.
condonation petition. Appeal lies.
Appeal, well, appeal was returned back to the petitioner. Your Lord. Returned to the petitioner.
No, second appeal lies in such cases.
In the appeal, there was no order.
No, you answer my query. First appellate court
Dismiss the condonation.
dismissed the appeal on the ground that
This appeal was returned back to the
it
petitioner.
cannot be returned. It is dismissed on as barred by limitation. Then whether 227 lies or a second appeal lies.
Section 27, I filed petition before. Your Lordship.
You answer this query. Take instruction and answer this query. Satisfy this court that 227 lies.
Give me a date. Your Lordship.
When?
Any date, Your Lordship.
Monday.
Monday, Your Lordship.
Okay.
Obliged.
On request of Ms. A. Begum, learned counsel for the petitioner, let this matter be listed again on 22nd June.
22nd, it is difficult for me also. 22nd is difficult for me, Your Lordship. Any date over. 24, Your Lordship.
24 June.
May it please your lordship. In this case, the petitioners are plaintiffs, lordship. They filed a suit against government. And thereafter, lordship, some private parties implicated themselves in the suit, and thereafter they filed
As defendant.
as defendants, lordship. And they contested the suit, lordship. And while the suit was filed against government, there was an injunction order that is in page 51, annexure 3. Procedure against the principal defendants, OP number 1 to 4. 1 to 4 were government's, lordship. The plaintiffs petitioners prayed for temporary injunction restraining the principal defendants opposite party number 1 to 4 from allotting the suit land to any other person or from doing any act in respect of possession of the plaintiffs petitioners over the suit land. Petitioner's case is that is their Miadi land. It was wrongly made government first, so government was made party. Then this injunction order was passed, lordship. But after implement of the private defendants, no injunction order was passed against them, though we have filed one application that is under section 151, page 54. Paragraph 3, your lordship. Page 54, paragraph 3, that the defendants with Raju Mia, Helaluddin, Abul Hussain, Samsuddin and Belaluddin on 8/11/2002 set up water pump and began to suck water from the suit land with a view to cut earth from the suit land and broadcasting in the locality that they will cut earth from the suit land and will change the nature and feature of the suit land. The suit land is borough paddy cultivable land and low-lying land, and if the defendant will suck water from the suit land and will cut earth from the suit land, it will change the nature and feature of the suit land. Hence, for the protection of the suit land and its nature and feature, the learned court may direct the police of Karimganj PS to protect the suit land and restrain the defendants from sucking water from the suit land. Though this is not an injunction petition, but under 151, it was prayed that to protect the suit land, as already there was an order to maintain status quo by protecting the suit land. That was rejected, lordship. Page 57, annexure 5. This, after rejection of this petition, the defendants filed an application. That is page 58, annexure 7, lordship. 6, lordship. Paragraph 1, that the added defendants have in possession of the suit land since the time of their predecessor.
Filed this.
Added defendants.
Newly implemented.
Newly implemented defendants. After filing the written statement, they filed this petition under section 151. Paragraph 1, that the added defendants have in possession of the suit land since the time of their predecessors for a period beyond limitation. The Assistant Settlement Officer Karimganj Sribhumi was pleased to issue possession certificate on 2nd January 1983 in favor of Masaid Ali, the predecessor of the added defendants. A photocopy of the said possession certificate has earlier submitted by the added defendants. So their prayer was in this petition. Page 62. It is therefore prayed that your honor would be pleased to pass necessary order for forwarding a copy of the order dated 9/12/2022, that is the injunction order in favor of the government, lordship, to the OC Sribhumi Police Station with a direction to restrain the plaintiffs from interfering with the possession of the added defendants.
This
in the-
9/12/22 was against the government,
Against the government.
not to allot it to anyone.
Yes, lordship, that is the injunction order, page 51, annexure 3. Though this is against government, the main statement of the court is that may I read page 51 for a moment, lordship?
Yes.
Page 52, last paragraph is important, lordship. On perusal of pleadings of the parties, it is found that the plaintiffs petitioners are claiming their ownership over suit land as their paternal property and the same is made khas illegally. But whether the suit land is the paternal property of the plaintiff's petitioners or not can be determined only after scrutiny of evidence, and without evidence, matter of ownership cannot be determined. What is important at this stage is to protect the suit subject matter of the suit, that is the suit land. As such, at this stage, an order of status quo. So the basic intention of the court was to, Lordship, what is important at this stage is to protect the subject matter of the suit, that is the suit land. As such, at this stage, an order of status quo will be the right approach which will protect the subject matter of the suit. Hence, for the interest of justice and to protect the nature and feature of the suit land, an order of status quo may be passed. Therefore, both the parties are directed to maintain the status quo regarding the present nature and feature of the suit land till the disposal of the main suit. So there is already a status quo order in favor of the government parties, Lordship, but we have also filed one application under section 151 to protect the suit property to maintain status quo against the added defendants also. That petition was rejected, and therefore the added defendants filed a petition and said that, Lordship, as their injunction order was rejected, injunction prayer was rejected against us, they cannot implement the injunction order against government, against us by helping the police or by calling the police. They cannot prevent us from doing any act over our suit property. That is their contention in the petition. So they prayed that that injunction order may be sent to OC Sribhumi police station with a direction to restrain the plaintiffs from interfering with the possession of the added defendants in the way of water sucking and cutting earth from the suit land for the above purpose. Against this, Lordship, we have filed our objection. Page 64, Annexure 7 is the objection. But learned trial court allowed this petition and held that the impugned order is at page 67, order dated 7/4/2026. Last paragraph, Lordship. By the aforesaid petition, petitioner defendant has prayed for imposing direction upon the plaintiff and forward a copy of order dated 9/12/2022 to the officer in charge Sribhumi police station for ensuring enjoyment and possession of the petitioner and added defendants over the suit scheduled land without any interference from the plaintiff in any way. The petitioner defendant further submitted that the suit land in question is a low-lying land which they use for fish farming, and during winter season by sucking water they catch fish and also cultivate the paddy over a part of land, and these facts are open and known to all. When the suit was filed by the plaintiff against the government, the added defendant petitioner appeared before the court and impleaded them on the record, but the plaintiff never took appropriate steps against them, and thereby ad interim injunction order was passed by this court on so-and-so in miscase number so-and-so, by which the defendant number 1 to 4, that is the state of Assam, and its officials were restrained from allotting suit land to any other person, never any reality imposed against them. So in such circumstances, Lordship, when added defendants petitioners claim passed on the ground that they are in exclusive possession over the suit scheduled land, any kind of interference from anyone, more specifically police authority, who were misled by the plaintiff, showing said order dated 26/2/2015 is nothing but an intentional framework to prejudice interest of the petitioner. The plaintiff intentionally can conceal the subsequent order of this court passed on 9/12/2022. 9/12/2022 is our section 151 petition. By this order, our petition was rejected, Lordship. Considering the prayer of the plaintiff and their petition being 3207, whereby they have sought direction of the court for proper implementation status quo order dated 26/2/2015 and compliance of the same by the added defendant petitioner, and having considering the matter on record, the court with observed order dated so-and-so never imposed against the petitioner. Hence, compliance cannot be sought from them and thereby pleased to reject the prayer. But the plaintiff relied on the status quo order dated 26/2/2015 and concealing the subsequent order dated 9/12/22 repeatedly approached the concerned police officials, Sribhumi, and causing hindrance on the right of enjoyment of the petitioner and repeatedly depicting their wrong intention. So court held that in such circumstances, petitioner defendants have prayed for restraining the petitioner, that is the contents of the file, the main findings given in page 70. Lordship. Thus, considering all this, court of opinion to forwarding a copy of order dated 9/12/2022 and this order to the OC Sribhumi PS is necessary to ensure the enjoyment possession over the suit land by the petitioners, defendants without any interference from plaintiff and especially from the police official. So the court, Lordship, allowed the added defendants to enjoy the property where a suit is already pending and adjudication is going on. Suit is at the stage of cross-examination of PW1, Lordship. Normally, it is the basic intention of the court to protect the suit property during the pendency of the suit, Lordship. So,
No, they are only pumping out water from
Lordship,
the
they are
suit land.
changing the nature and feature of the
How?
suit land. They are pumping out, Lordship,
Water.
water from the suit land.
Or fishing only.
Yes, Lordship, and thereafter they are in the dry season, they are going to cultivate the suit land, Lordship, with
Yes.
the help of this, Lordship. So basically, the court granted possession in favor of the defendants without any, Lordship, evidence. So already this order made my suit infructuous.
No, actually, what is the status at the time when 9 order on
Court is helping the defendants to, Lordship, possess their suit lands. That means already we are dispossessed from the suit lands, Lordship. But the court and the prayer of the plaintiff is that right title interest and confirmation of possession, and defendants are also saying that they are in possession. So without going for any evidence, who are in possession of the
which order you are impugning?
this 7/4/2026, by which their petition was allowed, Lordship. So in fact, Lordship, by this order, court is empowering the defendants to take the help of police to, Lordship, use their suit land. That means court already allowed them to enjoy the suit property, Lordship. So my submission is that, Lordship, the court committed illegality by allowing one party to enjoy the suit property when the suit is going on and there is an issue decided by both, issue is pending between both the parties.
Now we cannot say.
While adjudication is going on, suit is going on, Lordship, whether
It is
we can say that defendants are in possession of the suit property without taking any evidence. In fact, our pleadings were earlier than the defendants, Lordship. We pleaded that we are in possession of the suit property and government made the suit land illegally, government has.
Okay, we are issuing notice, no
Lordship.
interim.
Lordship, this order may kindly be, Lordship, stayed. Otherwise, with the help of this order, Lordship, the police will help them to enjoy the
No,
property
we'll consider stay only after service,
after returnable.
after return. Heard Miss Ram Chaudhary, learned senior counsel assisted by Miss B. Hajorika, learned counsel for the petitioners. Also heard Mr. T. R. Gogoi, learned government counsel appearing
1 to 4.
on behalf of, or appearing for respondent number 1 to 4. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 7/4/2026, whereby the Court of London, Civil Judge Senior, Civil Judge Junior Division Karimganj has forwarded the copy of order dated 9/12/2022 to the officer in charge of Sri Bhumi Police Station with a direction to ensure enjoyment of possession over the suit land by the respondent number. Who are the respondents?
Lordship, they are from 5 to
Respondent number
5 to 23.
5 to 2023. Stop. Let the notice be issued to the respondents. Since Mr. Gogoi has already appeared for respondent number 1 to 4, no formal notice. 1 to 4, no formal notice need to be issued to the said respondents. You have received the copies.
But the extra copy may be required.
I have served only one copy maybe at the time of filing.
The petitioner is directed to furnish requisite numbers of extra copies of the petition along with annexures to the learned government council. The petitioner shall also take steps for issuance of notice upon the remaining respondents by speed post as well as by usual mode within say
May I pray to take step by usual process and Lordship Dusty service upon the engaged counsel who is representing them before the learned trial court, as because there are so many respondents, Lordship. It will take time. Your Lordship has not granted any stay order.
speed post within 7 days from the date of this order, returnable on 5th of August. The petitioner is also allowed to take steps for issuance of notice on the engaged counsel of the remaining respondent before the trial court by way of Dusty mode. Stop. In the event the notice is served by Dusty mode, the petitioner shall submit an affidavit in compliance thereto on the next date fixed. List accordingly.
I pray that my suit may be stayed and the suit will not proceed further till the decision of this case. Though I have not prayed for Lordship stay of the suit, but if suit proceeded, the cross of PW1 is going on, Lordship.
Learned senior counsel for the petitioner submits that the suit filed by the present petitioners may be stayed till the disposal of this interlocutory and till the disposal of CRPIO, as the suit is proceeding at the stage of cross-examination of PW1. The prayer is allowed. The title suit number, if there is any counterclaim,
No, Lordship. 137/2014.
the title suit number 137/2026 is stayed till next returnable date. List accordingly.
Deeply obliged.
Public.
It's 42.
Where is the impugn order?
If I have calendar order dated 10/3/26, operative at your lordship, 45, bottom. Page number 45, bottom.
Yes, what was the
My lord, in this case, trial court has rejected the petition of the petitioner for reconnection of electricity on the ground that trial court has no jurisdiction.
Yes.
So, Your Lordship, if you want to permit, I want to submit a case law. Lordship, kindly page 2 of my citation. I'm the only the relevant part.
Page, para,
Bottom of third para. Para 18, bottom of third para.
yes.
Yes, sir, Your Honor, my lord, from the aforementioned pronouncement of law, it is discreditable that probate court has the jurisdiction to pass necessary order for the protection of the subject matter of the testamentary disposition. It cannot be unresponsive to imminent threat of material change in the existing condition of the property.
But
Under
this
the will-
relief is not for protection. You are seeking relief of electricity connection. That is not for the protection of the subject matter. How it will protect the subject matter?
Your Honor, my lord, in this citation, in the last page,
Okay.
Last page.
We are issuing notice. We are issuing notice. Heard Mr. T. Roy, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, impugning the order dated 10/3/2026 passed by the Court of London Additional District Judge number 1, Kamrup Metro, in probate title suit number 13/2024, whereby an application filed by the present petitioner for restoration of electricity connection in the where
top images.
in the shop,
It is mentioned in page 29, Annex 3. I have made the petition. It is supplied in the shop room of the petition.
the shop room of the petitioner was rejected. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of August.
Interim pair is
After July,
July last part. Last week,
23rd July.
Majole.
Item 9.
Please, Your Lordship. Lordship, by this petition, I'm impugning the order dated 13th May of 2026, passed by the Learned Family Court. The Learned Family Court basically dismissed my amendment application on the sole ground that it has been filed belatedly. However, Your Lordship, the ground is our ground is that, it is necessary that the that our written statement be amended so that the real question of controversy can be adjudicated. And also in view of Section 35 of the Special Marriage Act, which ensures that equitable matrimonial relief can be sought by the respondent spouse in the same proceeding, Your Lordship. So these are the primary grounds.
What is the stage?
And the stage right now, it's only that the evidence affidavit has been filed by the petitioner, which is the husband, the petitioner husband.
Okay, we issue notice. Who filed the divorce? It is a divorce suit.
It is a divorce case.
Who filed this suit?
The husband.
You are husband or wife?
I am the wife.
Okay. Heard Mr.
PK Deka,
B.
Bidit Deka.
B. Deka, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner Sneha Das, impugning the order dated 13/5/2026, passed by the Court of London, Principal Judge Family Court Number 1, Kamrup Metro in FC, within bracket civil, case number 890/2023, whereby an application filed by the present petitioner under Order 6, Rule 17 of the Code of Civil Procedure 1908, seeking amendment of a written statement, was rejected. Issue notice to the respondent.
Lordship, stay may be granted also, interim stay.
The You are Sneha Das.
Yes, Your Lordship.
What is your husband's name?
Sabnam Gogoi.
Okay. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post, as well as by usual mode, through within 7 days from the date of return, within 7 days, returnable on 7th of August.
Your Lordship, the matter is before the family court on 28th of June.
The further proceedings of FC Civil Case number 890/2023 shall remain stayed till next returnable date. List account.
Much obliged.
Item 10.
Your Lordship, the matter may be passed over for the time. My senior is at on legs. Obliged.
Item 43 for supplementary.
May I please, Your Lordship?
Yes.
My lord, this CRP is against the apportionment order, which was referred before the learned district judge Jorhat, my lord. So basically, impugn order is that starts from page 54. The observation, it starts from para 22.
Apportionment of the compensation.
Compensation, my lord, in the land acquisition matter.
Okay.
So basically, the acquisition was given to the tenant, my lord, who was considered as an occupancy tenant. So, and the pattadar, I'm for the pattadar, my lord, the petitioner here is the pattadar. So compensation here was given to him only 25%, and the compensation given to the occupancy tenant, the so-called occupancy tenant, is 75%. So mere possessor, they can get only the zero compensation, not the full compensation, my lord. So that is my humble prayer before Lordship. And in this proceeding, the learned district judge has traveled beyond his jurisdiction and considered him as a occupancy tenant, my lord. So to consider as an occupancy tenant, he has to apply for that, my lord. He is entitled under section 23 of the Assam Temporary Areas Tenancy Act 1971, my lord.
Whether compensation has been dispersed.
No, right now not.
Heard Mr. B. M. Deka, the learned counsel for the petitioner. This application under section 115 of the Code of Civil Procedure 1908 has been filed by the petitioner, Srimati Itobonta Borwa, alias Itobonta Borwa, impugning the judgment dated 4/5/2026, passed in LA Miss case number 4/2022 by the Court of London, Additional District Judge Jorhat, whereby the apportionment of the compensation awarded for the acquisition of the land of the petitioner was made in the ratio of 3:1,
Yes,
3:1 between the respondent and the present petitioner. Learned counsel for the petitioner submits that the trial court erroneously held the petitioner to be an occupancy tenant and thereby granted him an enhanced rate of compensation. Issue notice to the respondent. Records should be necessary.
my lord,
Records should be necessary.
that may be, yes, that may be called for.
Let the scanned copy of the records of LA Miss case number 4/2022 be called for from the concerned court. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of August. List accordingly.
The compensation may not be released, my lord, till then.
Till next returnable date, the impugned judgment may not be given effect to list accordingly.
Much obliged.
44.
My friend, my lord, this petition is directed against the impugned order passed by the DRT lawsuit.
DRT,
DRT. Way proceeding. This is not a service report. Way. So I filed an application before the DRT lordship under order 11 rule 14, which provides for the production of the document. And that by the impugned order, my petition was rejected solely on the ground that the bank had earlier produced the document.
same document which you are intending.
Lordship.
Bank has produced the same document which you were intending to produce.
Original lordship along with the petition. Original
Where is the impugned order?
impugned order
Page.
lordship page. Copy of 236. Yeah, copy of 236. Page मिली है sir. Page 234 lords. 236. Huh? 236. 233. It is start from page 236, annexure 6. Operative portion lordship.
236.
Yes, Lord. More कुछ आरु एक copy आता नहीं लाइसेंस. But it last page. Yeah, last page. %.
Yes. Why the DRT rejected?
Pardon, my lord.
Why your petition was rejected? What is the reasoning?
My petition was rejected, lordship.
Because the documents which you are seeking a direction to be produced by the bank were already annexed by the bank in its original application. That is the reason.
Lordship, what happened on the day of inspection? No, I was not good health. I some chest pain, so I did not go on that day. My learned junior had gone. He was a quite new junior. Then I filed a formal petition which are mandatory provisions, lordship. Order 11, Rule 14 of the CPC, which applies in the DRT also. It is mandatory provisions, lordship, that if an application is filed, the document should be produced by the applicant. I have quoted the provisions of the lordship.
No, but DRT is saying that the documents were already annexed by the bank with the.
Those are Xerox copies, lordship. Here there is a dispute of regarding the signatures, lordship. In the petition, we have specifically stated that the bank has shown a liability of 1,99 lakhs, lordship, and some amount transferred to unknown accounts, lordship, which never was authorized by the petitioner's lordship.
What is 1114? Order 11, Rule 14.
It is mandatory, lordship. It should be. Well, lordship, if lordship has perused order 1114, it shall be lawful for the court any time during the pendency of the suit to order the production by any party thereto upon such of the documents in his position or power relating to any matter in question, and such and the court shall think right, and the court may deal with such documents when produced in such matter as shall appear just. So, lordship, at any stage of the proceeding, your lordship, it can be application under order 11, Rule 14 or 15. Can we file, lordship?
15 gives you a right to inspect. That option was granted to you.
Yes, option was granted, but that should be judicially exercised, lordship. Your lordship, be pleased to consider that in the impugned order, finding has been given that this will be decided at the time of the final hearing. Lordship, you are aware that in the DRT tribunal, no evidences are recorded, no cross-examination provision is there, lordship. So if it is decided by the Honorable Presiding Officer, lordship, then I will not be in a position to take the proper defense. And if the law itself provides that any stage of the suit will cause serious prejudice to me.
Heard Mr. S.P. Roy, the learned counsel for the petitioner. Petitioners. This application under Article 227 of the Constitution of India has been filed by the petitioners, impugning the order dated 24/2026 passed by the Debt Recovery Tribunal, Gauhati in IN number 730/2024 in original application number 183/2023, whereby the application made by the present petitioner for production of documents and inspections thereof by the petitioners under Order 11, Rule 14 and 15 of the Code of Civil Procedure 1908, read with Section 19, 25 of the Recovery of Debts and Bankruptcy Act 1993 was rejected. Learned counsel for the petitioner has submitted that though as per directions of the DRT, the bank had produced the original documents. However, on the day when they were produced, due to ill health of the learned counsel for the petitioner, same could not be inspected. And the correctness of same could not be inspected. However, the trial court by the DRT by the impugned order has observed that there is no need to produce the original documents. Thereby, the petitioner would be deprived of his right to inspect the document as provided under Order 11, Rule 15 of the CPC. Let the notice be issued to the respondent. Bank is the respondent.
Bank is respondent number one.
Respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order. Returnable on 7th of August.
Further proceeding may be still then.
Of the original application.
Yes, further proceeding. Because matter is fixed for final hearing on 2nd of August.
Final hearing.
Huh? 13th of. Final.
Learned counsel for the petitioner submits that the original application has been fixed for final hearing on 13th, when? 13th of August.
August.
Considering the submissions made by learned counsel for the petitioner as reflected in the foregoing, as discussed in the foregoing paragraph, further proceedings of original application number 183/2023 shall remain stayed till next returnable day. List accordingly on after 7th, after 15th. After 15. 19th of August.
Published.
Lordship, the matter may kindly adjourn for today, Lordship. We'll file our additional affidavit in this case. So be here.
What additional affidavit?
As in order.
We have filed our objection. Already 2 times the special Foxu judge has already rejected his bail. Now suppressing all these things, he has approached this honorable court. I have annexed the orders of the.
Lordship, I am actually the proxy counsel. The engaged counsel, Miss P. Bora, is not in the court today. The matter may kindly be fixed on vacation.
Heard Mr.
US Bora.
U.S. Bora appearing on behalf of Ms. P. Bora,
P. Bora.
learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, as well as Mr. A. Dhar, learned amicus curiae, who submits that the respondent number 2 has filed a written objection today. Has filed a written objection today. Learned counsel for the petitioner submits that the petitioner intend to file an additional affidavit against the objection filed by the respondent number 2 and seeks some time for the same. Prayer is allowed. Let this matter be listed. 27 July.
Lordship. Much obliged.
I did 45 from supplementary.
Yes.
Yes, Lordship. Lordship, some time may be granted so that we can file our written objection, Lordship.
Anticipatory bail.
Lordship, on this Friday, we will file our written objection. Lordship.
Next week.
Next week.
Heard Mr. K. Bushwell, learned counsel for the petitioner. Also heard Miss, what is her name?
P. Rafa.
P. Rabha, learned counsel appearing for NCB, who prays for some time for filing written objection against the bail, anticipatory bail application. The prayer is allowed. Let this matter be listed on 22nd June.
Forward. I did 20.
May I please, Your Lordship? Lordship, as per office note dated 1/6/26, neither AD card nor unserved notice has been received with regard to respondent number 2A and B, Lordship. And with regard to respondent number 2C and D, I was instructed to get new address. However, Lordship, I have not received address of both the respondents. I've only received address of one of the respondents, so I'm seeking some more time to get the correct address.
Heard Mr. D. Majumdar, the learned counsel for the appellant, who seeks some more time to get the correct address, correct postal addresses of respondent number 2C and 2D. The prayer is allowed. Let this matter be listed 10th of August.
Much of that.
I did 21.
Yes, Mr. Chaudhary. Mr. Laskar, you are appearing for the sole respondent.
Respondent number 1A to 1E. Respondent number 3B to 3F. 5A to 5G. And respondent number 6 also.
You are heirs of the deceased respondent.
Yes. They are the legal head. The disease respondent number 1. 3 and 5.
None has appeared for the appellant on call. Mr. T.U. Chaudhary, T.U. Laskar appears for respondent number 1A to 1E, 3B to 3F, and 5A to 5G, as well as respondent number 6. It appears that no, we are giving one more chance. Let this matter be listed 29th of July.
Apply.
May I please, Your Lordship? On last occasion, this court has directed me to ascertain the address of the respondent. Lordship, till date, we could not be able to find the address of the respondents. So I required some more time to find the address.
And Mr. K. Jain, learned counsel for the appellant, who submits that in spite of the directions of this court issued by even on 27/5/2026, the appellant is unable to find out the correct address of respondent number.
So all the respondents except respondent number 6, they have appeared.
All the respondent except respondent number 6. Therefore, 6 some more time for the same. Stop. On the other hand, Miss what Arbora appears for respondent number 6. The prayer is allowed. Let this matter be listed on 10th of August.
Much obliged, Lordship.
Yeah, please, Your Lord. Lordship, this appeal is ready regarding service and records.
Time for respondent number 1.
Heard Mr. G. Bhardwaj, learned counsel for the appellant. Also heard Mr. A.K. Mishra.
A. Mishra on behalf of Mr. S. Das.
A. Mishra appearing on behalf of Mr. S. Das, appearing for respondent number 1. It appears that this appeal is ready for hearing. Hence, let this matter be listed for hearing. 10th of September.
Alia.
Item 24.
May I please? I'm appealing for respondent number 1, 2, and 6. Lordship. Office note of 12/6/2026.
None appears for the appellant. Mr.
A. Borua.
A. Borua appears for respondent number
1, 2, and 6.
1, 2,
And 6.
and 6. It appears that the service report in respect of notice issued to respondent number 5 has returned with a endorsement that the address is not found. In view of above, whereas the AD card issued to pro forma respondent number 7 along with the notice sent to him has been returned. with signatures of the addressee thereon. Hence, the notice is signatures thereon stop. Further, the service report in respect of notices issued to respondent number 3 and 4 are still awaited. The appellant is directed to take fresh steps for issuance of notice upon respondent number 3, 4, and 5 afresh by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of August.
Please, Lordship. Lordship, I am appearing on behalf of my senior HOD. Service report for respondent number 4, 5, 6, and 7 has not been received.
Mr. What is your name?
Z. Dutta on behalf of HOD.
Z.
Z. Dutta.
Datta, Learned Counsel, appearing on behalf of Mr. H. Chaudhary, the Learned Counsel for the appellant. It appears that respondent number 1 within bracket 1, 1 within bracket 2, and 1 within bracket 3 have filed the wakalatnama of their engaged counsel. However, in respect of the other respondents, the service report have not been received. As such, the appellant is directed to take fresh steps for issuance of notice upon remaining respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of August.
May I please, your Lordship. Lordship, here as per last order 27/5/26, there was a direction upon the respondent number 1, legal assessor respondent number 1, if they are willing to provide the names of the legal assessor respondent number 1D.
1.
D. Para number 6, my lord, proceed. Last order.
Yes.
Also, we are unable to connect offline. Also, may kind gives me more time to obtain necessary order.
You also try to collect.
Yes.
Heard Mr. G. Bhardwaj, Learned Counsel for the appellant. Also heard Miss, what is her name?
M. Devi.
M. Devi, Learned Counsel for respondent number 1A within bracket 1B, 1C, and 1E. Though the Learned Counsel for the respondents, appearing respondents, was requested by this court to provide the address of respondent number 1 within bracket D to the Learned Counsel for the appellant. However, it is submitted by Learned Counsel for the respondents that the said respondents were unable to collect the present address of the respondent number 1D and seeks some more time for doing so. The prayer is allowed. Let this matter be listed on 10th of August.
Elliot.
Item 29.
My lord, in this case, service is complete, my lord. And has already been admitted also. So let the
Record,
matter be.
records, trial court record.
Records has not.
Records would be necessary.
Records will require.
Heard Mr. S.K. Ghosh. Learned counsel for the appellants. Also heard Mr. M.H. Rajbor, the learned counsel for sole respondent. Sole respondent. Stop. It appears that the records of the trial court, though the records of the trial court have been received.
My lord, trial court records will suffice the purpose.
Appellate's court.
May not be required because here in this case, question is when the suit was dismissed for default without restoring the same, my lord, counterclaim only proceeds, and against the counterclaim, appeal has been preferred. And the lower appellate court allowed the suit, my lord, without considering the trial court order passed on.
Allowed the suit or allowed the counter?
Allowed the suit.
Without
I am the
restoring?
counterclaimant.
Okay.
I am the counterclaimant. Our counter.
Yes, Mr. Rajbur, whether appellate's court record would be necessary.
Appellate court and record agreement.
The record is required.
Judgment is there.
Both the records be available.
Judgment is there.
Yes, judgment is there.
Judgment will suffice.
Even I in the memo of appeal I have annexed all the records. Order sheet, entire order sheet I have annexed.
Mr. S.K. Ghosh, learned counsel for the appellant submits that considering the substantial question of law which have been formulated in this case, the perusal of appellate's court record may not be necessary since the trial court records have been received. He submits that matter may be fixed for hearing. The prayer is allowed. Let this matter be listed for hearing.
My lord, there is an IM, my lord.
8th of September.
Immediately after available of the record, my lord. If the urgency is there, my lord, I am disposed for myself. Recover your product.
No, we are not calling for appellate's court record. We'll go for hearing. What is the
IM, my lord.
I for?
Stay. It has already been granted till returnable date.
Okay.
Let the IM may be disposed of.
Till the record is available, the matter is filed, my lord. A date may be
8th of September.
8th of September.
the record will be, if the record is available, by that time available, my lord, 8th of September.
Heard I heard Mr. S.K. Ghosh, learned counsel for the applicant. Also heard Mr. M.H. Rajbor, learned counsel for the sole respondent. It appears that by order dated 19/12/2025, the execution of the impugned judgment and order dated 38/38/2025 was stayed by this court, and since stayed by this court till today. It also appears that in the connected appeal, substantial questions of law have already been formulated, and same is fixed for final hearing on 8th of September. Considering the above mentioned facts, this interlocutory application is disposed of with a direction that the stay granted on 19/12/2025 shall continue during the pendency of the connected RSA 219/2025. With above observation, this IA is disposed of. I'm taking a short break. What you are impugning?
Lordship, his apprehension in the year 2000, since the year 2020, the defendant who is sharing the northern boundary of the present petitioner's plot of land, Lordship, he was trying to encroach into the plot of land of the present petitioner, Lordship. And the first attempt was made in the year 2020. And when the final attempt was made in the year 2021, then this suit was filed also. And against the present suit, the defendant, he was alive at that time. He filed a written statement along with a counterclaim also. Both the claims, Lordship, the present petitioner's claim is that they are trying to encroach into our plot of land. And the defendant's claim is that we have already enclosed. That is the crux of the matter, Lordship. And regarding the identity of the land, there is no pleadings in the either of the parties, Lordship. And plot of land is well bounded, boundary is well confirmed, Lordship. And thereafter, Lordship, issues were also framed. And in the year 2022, during the lifetime of the original defendant, Lordship, he filed a petition under Order 26, Rule 9, Lordship. So praying to form an advocate commission, Lordship. And that was rejected, Lordship. That order, your Lordship, will find at page number 59, Lordship, 24/2025. And learned trial court was of the opinion that the advocate is not an expert, so that petition was rejected, Lordship. And subsequently, the original defendant, Bhavani Sharma, he expired, Lordship. In his place, his legal heirs, the present respondents, Lordship, they were included. And representing all the legal heirs, Lordship, his elder son, Vishal Sharma, has filed another petition under the same provision, under the same cause of action, Lordship. And the petition also is the verbatim reproduction of the earlier petition, Lordship. Now they are seeking advocate commission along with a appointment of a Latmandal to measure the land loss and also to formulate an opinion whether it is a annual pattalan, tosi pattalan or periodic pattalan loss. But with regard to these issues, there is no doubt from either of the parties loss. But having been objected from the petitioner's loss as a plaintiff, and that petition was allowed on 21/2/2026.
Where is that order?
That order is at page number 73, also. Earlier, against the earlier order, Lordship, the present defendant neither filed an revision or appeal under the appropriate provision of the code, Lordship, nor, and as such that order 2/4/2025 attained finality, Lordship. So that order is binding, equally binding upon the present respondents also.
No, whether the trial court was pointed out regarding the earlier rejection order, whether it was brought.
That was pointed out. From our side, we have pointed out also, in
Whether-
our objection also.
Whether that was taken care of in the.
In the order, that is not visibly taken care of, also.
Any discussion made?
I have not seen anything, Lordship. And in this particular order, Lordship, the earlier rejection of forming an advocate commission, that is also allowed, Lordship. Once Samarjit Sharma, he is an advocate. He has been appointed as a commissioner, and along with that, the concerned circle officer was directed to measure the land and to other, with regard to the other prayer of the defendants also. And your lordship knows it very well, unless there is a question of identity of the plot of land, lordship.
Where is the, when is the next date fixed?
Next date fix is the 1st of July, lordship.
Whether the report has been filed?
No, lordship. The other side, in fact, lordship, they are now desperately trying to come into the encroach into the plot of land forcibly, lordship, and at some point of time they are threatening the present petitioner plaintiff also. They will forcibly
No,
break in.
you are aggrieved only with the order of.
We are agreed only with the orders. Just
pending
I'm just present in the latest development, lordship. The 1st of July is the next date fix of lordship, and in this as I have already submitted, lordship, there is no pleadings or there is no question regarding the identity of the plot of land, lordship. And lordship, the issues only the suit is also at an early stage.
Mr. D. Das, Learned Counsel for the petitioner. This application under Article 227 of the Constitution of India has been preferred by the petitioners. Petitioner. Impugning the order dated 21/2/2026 passed by the Court of Learned Civil Judge Junior Division, Udalguri, in Miss J case number 87/2025 in connection with title suit number 3/2021, whereby the prayer of appointing an advocate commissioner to survey to inspect the suit land and also a direction to the concerned Lat Mandal to conduct survey of the suit land and thereafter furnish a report regarding as to whether the suit land is a Tozi land, annual patta land or periodic patta land. Learned Counsel for the petitioner submits that the predecessor in interest of the present defendants had earlier filed an exactly similar application under Order 26 Rule 9 on 24/3/2022. The said application was dismissed by the trial court on 2/4/2025. However, he submits that after death of the original defendant, when his legal heirs were substituted, the eldest son of original defendant again filed an application under Order 26 Rule 9, seeking the exactly same relief which were earlier rejected by the trial court when the original defendant filed a similar application. He submits that the trial court, without considering its earlier order, had passed the impugned order whether principle of res judicata is applicable in case of orders. Pass the earlier order, pass the impugned order, and hence he submits that same is illegal and required to be interfered with. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by within 7 days from the date of this order, returnable on 10th of August. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraphs, the operation of the impugned order dated 21/2/2026 passed in Ms. J case number 87/2025 in connection with title suit number 3/2021 shall remain stayed till next returnable date. List accordingly.
Further proceeding may also be stayed also.
No. Why for further proceeding? Only commission is stayed.
That's,
Suit will proceed.
that's.
Item 30.
Three, 1-3. Yes.
Made. The appeal was abated, thereafter we filed setting aside abatement application and for substitution. So we delay, condemnation of delay petition, delay for 1038 days.
1038 days.
38 days. What happened in this case, during COVID period, on 19/9/2021, appellant died, but we had no information regarding his death. Only on
No, Lordship, now the appellant's deceased son and his wife has filed the application.
let me submit.
Application. Therefore, the knowledge about death of his father or husband
No,
is not known to
that is not
the
that.
appellant, is not incorrect.
I have explained in paragraph 3.
Who are you?
We now these legal years of the appellant have filed this application.
What was not known to
The
you?
one wife, petitioner number 1.1 wife, and the other son and daughter. What happened in this case, only on 19/3/25, appellant's advocate could know about the death of the appellant, and immediately thereafter, we could try to contact his son, because he was an old as a person, and he was an advocate also. His son was asked to keep contact with us, but unfortunately his son also died after handing over during the pendency of the appeal. He died on 7/6/2014. So we have no contact with as an advocate, we had no contact with the appellant, And regarding his death also, we were dark about it. And the other legal heirs,
We means the lawyers.
Lawyers.
Engaged
I was
counsel.
the engaged counsel at that time, During pendency of the appeal, he died, and we had no knowledge about it. And thereafter, his son also died, in 2014, who was keeping contact with the advocates regarding the appeal, In paragraph 3, I have given the details of facts regarding this, And only on 19/3/25, while the appeal was put on hearing, and then we could come to know that the appellant died at the information given by with the information given by the respondent, Then, in the meantime, we tried to contact the legal heirs, but this son who was keeping contact with us regarding the appeal, but he was also found dead thereafter, and we had no knowledge about it when our letters were not received by them. In paragraph 4, I have stated regarding this, and accordingly, in this way, the 1038 days delay was caused by the till filing of the abatement petitions, setting aside abatement petition and substitution case.
No, setting aside abatement has to be filed by the successor in interest of the
Yes,
deceased.
yes.
When they came to know about the death.
They came to, they did not know about the appeal, my lord. Only we have explained, my lord. They did not know. Huh? They, both the sons and the present petitioner, both the son and
When they came to know about the pendency of appeal.
after my lord, they dismissed the appeal on abatement, my lord. The respondent side came to started appealing in the plot, my lord. Then they came to knowledge of, about the appeal, my lord, while contacted their.
Where is that statement?
I am reading the paragraph 4, my lord. There is elaborate.
Paragraph number?
Paragraph 4, my lord. Page number 4, my lord.
Yes.
That late Lalit Chandra Pegu, the deceased appellant in the RSA, brought his son Raja Migam Pegu along with him while the case was handed over to the engaged counsel. Accordingly, Raja Migam Pegu kept contact with the advocate along with his father, but after 2021, none kept any contact with their engaged advocate. At present, it could be known from the deponent that both of them died already. The present petitioner number 1.2 came to know about the status of the case in the third week of May of this year, while they wanted to know from their engaged counsel about the status of the case. Since the respondent of the appeal, the plaintiff started art filling in the suitland.
No, this line you read again. When they wanted to know about the from
they
the
wanted
engaged.
to know about from their engaged counsel about the status of the case.
Stop. Status of the case means you were aware about pendency of an appeal.
In the month of May, in the month of May of 25.
In the month of May, you are saying that my query is when the present petitioner came to know listen to my query.
Yes.
When for the first time the present petitioners came to know that an appeal was filed by their predecessor.
It has been stated, my lord. The art filling was started, my lord, by the respondent.
Where?
Since the respondent of the appeal, in the plaintiff started the art filling in the suitland. Art filling was started, my lord, after the dismissal of the appeal on abatement, my lord. And then it came to the knowledge of the respondent number over 1.2 and 1.3, who used to reside, my lord, in Delhi. They do not reside there, my lord, in the Dhamaji, my lord. That is why they did not know about this, my lord. And they only
know about what?
My lord?
My query is when you came to know that your husband or father filed an appeal.
On 22nd May of 25. Art filling got started on 22nd May of 25.
What? Yes.
Well, thereafter, after knowing about the abatement, my lord, then the petitioners council were contacted, and thereafter, after contacting the advocates, some days could be required, my lord, for filing the substitution petition and abatement petition. In paragraph 5, we have explained the delay. And accordingly, my lord, 1038 days delay that was caused till filing of the petition, my lord. And there has been and from the date of knowledge, my lord, in fact, there was no delay, my lord, much more delay, my lord, only 72 delay in filing the petition. for
What is the
condemnation.
date of knowledge?
From the date of knowledge, my lord. Date of knowledge, my lord, that is from 22nd May to 2025.
Where have you stated?
Yes, my lord, I have stated in paragraph 4, my lord. The art filling in the suit land on 22nd May of 25, and this was the date of knowledge. My lord.
Knowledge of what?
Knowledge regarding the abatement of the appeal, my lord.
Before you came to know about abatement of appeal, you must be knowing about pendency of the appeal.
Tendency, matlab, say, in the appellate stage, matlab, during hearing, matlab, even after it was during the abatement of the appeal, matlab, we were dark about it, matlab, whether the appellant died or not. We were dark about it during hearing, matlab. And at the
No, the
instance of
lawyers may not be knowing, but the
the
success
other side informed, matlab, the other side informed.
inform the lawyers only, engage you.
Yes, matlab.
But the successor of the
Yes, sir.
deceased,
We could not contact the appellant because appellant died, and even the person who was engaged for keeping contact, because he was an old person, my lord, the appellant. And his son also died, my lord, unfortunately, in 2014. And that is also not known to me, my lord, known to us, my lord, regarding that. And we tried to contact his son, but we could not. Regarding the present petitioners, my lord, we don't have any information about them. So that is why it could not be known, my lord, regarding the date of the
item number. Yes.
So, my lord, we have explained the delay, my lord, regarding this, my lord, from the date of knowledge also, my lord, there is no sufficient delays, my lord, only 72 is delay in the filing of the petition. And it was happening during the COVID period, my lord, that is why, my lord, we could not have any information regarding this. So,
What was held by the trial court?
Trial court, my lord, the suit was decreed, my lord. Then we filed appeal, my lord.
Appeal was dismissed. Yes, Mr. Datta.
So first of all, we have filed an written objection, Lordship. On 2-3 counts, Lordship. First of all, so far as calculation of delay is concerned, it is from the date of the appellant, Lordship, not from the date of the knowledge. The law is specific from the date of the appellant. It should be first total 150 days, 60 days, 90 days and 60 days. Thereafter, due to COVID, Lordship, they will get another 90 days. So the date of the appellant was 19/9/2021. And the application for setting aside abatement, substitution of
No, date of appellant's death is?
Date of death of the appellant.
Is
19/9/2021.
Okay.
And the application, date of filing the application is 2/6/2025. So the total delay is of 1,352 days from the date of death to the date of filing application. From that, Lordship, first of all, 150 days, thereafter 90 days for COVID in terms of the judgment of the Supreme Court, Lordship. I have annexed there. It is, yes, page 17 is the relevant portion of the judgment of the Supreme Court regarding the benefit given to the litigants during that period is 3. In case where limitation would have expired during the period between 5/3/2020 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have
a limitation period of 90 days from 1/3/2022. In the event that the actual balance period of limitation is remaining with effect from so and so is greater than 90 days. So this, as per this provision, they will get 90 days, and in that event, the total day of delay is 1,111,3, let's say. It will be. And so far as rest part of the, let's say, I may be allowed to, it's better to go through the paragraph 4, let's say, I'll read it of my objection petition.
Yes.
That the deponent denied and disputes the correctness of the statement made in paragraph 6, 5, and 6 of the interlocutory application. It is stated that application is based on incorrect and contradictory pleadings. The applicants have set up a complete imaginary timeline to create an artificial cause for condonation of delay. The statement made in paragraph 3 and 4 are contradictory. The applicants at paragraph 3 states that late Raja Migam Pegu used to keep touch with the engaged advocate, but on 7/6/2040 he died, and since then there was no contract with their advocates. But in paragraph 4 of the interlocutory application, it is stated that Raja Migam Pegu kept contract with advocate, but after 2021, none kept any contract with their engaged advocate. It is stated that a person who died in 2024, the question of keeping touch with the engaged advocate till 2021 is absurd, contradictions exposes the falsehood of the application. Further, in the present set of counsel.
What is the date of death of the appellant?
It is Lordship 19/9/2021.
Then what happened on 7/6/2014?
7/6/2014, Raja Migam Pegu died. We did not.
We have not.
We have not.
Appellant, one of the son of the appellant, according to him, along with the appellant, his son, the deceased son, has also keep track of the case.
No. The sentence may be read, my lord, in paragraph 4. Accordingly, Raja Migam Pegu kept contact with the advocates along with his father, but after 2021, none kept any contact. That means, my lord, after 2021, father came, my lord, but none could keep contact. According to him, this is contradictory. It is not contradictory, my lord. We have stated that 7/6/2014 he died, my lord, and we don't have any contact with us, my lord, regarding this. Only after 21, my lord, but after 2021, none kept any contact with their engaged counsel advocate at present. After 21 means, my lord, the person died in 19/9/2021. So before his death, my lord, he came. But after death, my lord, no contact with us, my lord, regarding the this is the statement, and we have not stated that the Raja Migam Pegu met us in 2021.
Yes, Mr. Gupta.
And secondly, please to look the present set of engaged counsel has filed their power on set of counsels were engaged only on 25/12/2017. Thus, it appears that applicants are attempting to create an imaginary story of no contract to explain away their own negligence. The deponent further begs to state that the entire application, there is no statement that the applicants have no knowledge about the pendency of the aforesaid second appeal before this honorable court. Rather, from the statements made in paragraph 4, it apparent that they know about the pendency of the second appeal, and it was only after dismissal of the appeal when the deponent started work of art filling in the suit land on 22nd May 2025. The petitioner applicant number 1.2 came down to meet their advocate on 24/5/2025. Thus, from the above, it is apparent that there is no bona fide intent on the part of the petitioner applicants to pursue the appeal on merits, but only to desire to obstruct the respondents' lawful enjoyment of the property and is a calculated attempt to delay the proceeding. And the next paragraph, I have stated that the duty to inform the court and the advocate about the date of the parties rests on the legal heirs, not on the opposite party. The petitioner applicants, without informing about the date of the sole appellant, slept over the matter more than 4 years after abatement, which shows their gross negligence. Lordship, so far as ultimately this is, Lordship, not they have failed to show sufficient cause for condonation of delay. And that two statements they have made. One is that the father, his son, Raja Migompegu, keep the track of the case with the engaged counsel. And second, they have in their application, Lordship, at paragraph 3, they have clearly stated that till 2007, from bottom, the date of the so yes, after knowledge about was sent to Mr. Raja Migom Pegu regarding the current status of the proceeding. Yes, Lordship. 1, 2, 3, 4, 5, 6, 7, 8, before. From the bottom 9 kind above, Lordship.
In which para?
Para 3 of their Lordship application.
Yes.
From right side, Lordship. It is also pertinent to mention here in that let Raja Migompegu used to keep task with the engaged advocate, but on 7/6/2014 he died, and since then there was no contract with their engaged advocate. Next paragraph, Lordship, again, Lalit Chandra so and so brought, let Lalit Chandra Pegu, the deceased appellant in the RSF, brought his son, deceased son, Lordship, that is Raja Nigam Pegu, along with him while the case was handed over to the engaged counsel. Accordingly, Raja Migam Pegu keep contract with the advocate along with his father, but after 2021, none kept any contract with their engaged advocate. As it is at present, it could be known from the deponent that both of them have them died already. The present petitioner number, this is yes regarding the knowledge, Lord. They want to project that only after starting artwork by the defendant, Lordship, they came to know about the appeal, pendency of the appeal. Is there, but from their pleadings, Lordship, will find, I'm reading it, came to know about the status of the case. The present petitioner number 1.2 came to know about the status of the case. It is not about the knowledge of the case, it is the status, Lordship, of the case in the 3rd week of May of this year, while they wanted to know from their engaged counsel about the status of the case. Since the respondent of the appeal, the plaintiff, started art filling in the suit land, both the petitioner number 1.2 and 1.3 used to reside in Delhi due to their service in Delhi, and they were informed by their old age mother, that is applicant number 1.1, regarding the art filling in the suit land on 2nd of May 2025. Immediately thereafter, the petitioner number 1.2 came down to meet their engaged counsel in Gauhati on 24/5/2025. These particular statements never indicated that they have no knowledge regarding it. Rather, it supports that they have the knowledge, they're sitting ideal. Only when, after dismissal of the appeal, I started artworking, then they came back.
On what basis you claim the right over suit land?
That's it.
On what basis you have claimed? What was the dispute? Suit was for recovery or confirmation of possession? In your suit,
Yeah.
what relief you prayed for? Yes.
Recovery of possession.
Recovery. So you were in possession.
Yes.
On what basis they claim recovery?
मतलब
They have claimed on
We-
what basis?
we-
Whether they have purchased or inherited,
purchase
purchased from?
not from us, but some other person. There is dispute with regard to the land manager. What is their claim in respect to the suit land? That is not the suit land. We were in possession.
In second appeal, question of whether.
No, I am not going. I just want to know
Regarding merit of the case.
what was the dispute.
Say suit was decreed and in appeal, it was dismissed.
No, that is the minimum fact. But what was your claim based on what your claim was based on?
Our claim was that we were possessing the land since 50 years back, Melody. And
your title?
And title, Melody, only one document was there, Melody, regarding parcels of land, but it was not registered.
And their claim was?
Their claim was based on title, registered deed, but that particular land is not the parcels land of them. What we were in possession, that is a different land. That is the in the appeal, it was the suit was dismissed, and then
Lordship wants to go to the appeal, then I'll seek some time, Lordship, because I am not prepared so far as appeal is concerned. It's
No,
newly engaged.
I am asking only bare minimum facts.
yes.
Heard Mr. S.
The suit.
D.
Their
Chaudhary.
claim is on the basis of Lordship and unregistered sale deed and they have in condition.
D.
But they have
Chaudhary.
claim, and my claim is on the basis of a
The
registered
learned
sale.
counsel for the applicant. Also heard Mr. U. Dutta, the learned counsel for the respondents. Applicants and applicants plural, respondents singular. This application under Section 5 of the Limitation Act 1963 has been filed by the applicants praying for condoning the delay of 1038 days in filing the application for setting aside abatement on suit, abatement of the appeal on the death of original appellant. Stop. As well as for filing the application for substitution of the legal heirs of the original appellant. Mr. D. Chaudhary, the learned counsel for the applicants, has submitted that the predecessor in interest of the present applicants was the appellant, was the defendant in title suit number 3/20/2006 filed by the present respondent before the Court of Learned Munsif number 1 Dhemaji, Assam. The said suit was decreed in favor of the respondent against the stop being aggrieved by the said decree of the trial court. The predecessor in interest of the present applicants filed a title appeal before the Court of London. Putul, memo of appeal. being aggrieved,
Is. If you will just Hemazilo.
preferred an appeal before the court of learned Calicut. No, being aggrieved by the decree, judgment and decree dated 12/3/2010, passed by the trial court of Munsif Dhemaji, entitled suit number 3/2006. The predecessor in interest of the present applicants preferred a title appeal before the court of learned District Judge Dhemaji. District Judge.
Yes.
District Judge Dhemaji. The said appeal was also dismissed by the order, by the judgment
2012.
dated 10th 10/12/2010, passed by the district judge, passed by the court of learned district judge in title appeal number 1/2010. On being aggrieved by the aforesaid judgment of the appellate court, the predecessor in interest of the present applicants referred a second appeal, regular second appeal, under section 100 of the Code of Civil Procedure against the 100 of the Code of Civil Procedure. Stop. The said appeal was registered as RSA number 86/2012. It also appears learned counsel for the applicants has further submitted that in the said appeal by order dated 25/4/2011, the substantial question of law has been formulated and was formulated. Stop. However, on 19/9/2021, the appellant expired. Stop. And this court, by order dated 4/4/2025, disposed of the appeal by holding that by operation of law, the appeal stand abated on the death of the sole appellant. The learned counsel for the applicants submits that the knowledge of the death of the appellant was learned counsel for the applicants has submitted that the engaged counsel for the present applicants, who were also the engaged counsel for the original appellant, did not have the knowledge of the death of the sole appellant. He submits that this said fact came to be known to the present set of engaged counsel for the original applicant only when the, who informed you?
Both of them, it was in the earlier order, Lordship. I have intimated to the court regarding their father.
After giving intimation, we could come to know, but regarding these facts, they have narrated petitioner number 1.2 and 1.3. They are the resident of Delhi, and they came after.
When you informed Mr. Datta?
It's reflected in the orders, Lordship, last.
On the
Reflected in
However,
the orders before,
when,
before 2 days of the,
only when on 19/3/2020,
19/3/2020.
2025, the engaged counsel for the respondent informed the court regarding death of the sole appellant on 19/9/2021. He further submits that since the engaged counsel for the original applicants were not in touch with the original appellant since the year 2021, and neither they were in the touch with the son of the original applicant, namely Raja Migom Pego, who also had expired in the meanwhile. The present petitioners could not be informed by the present set of counsels regarding the dismissal of the appeal on getting abated. Learned counsel for the petitioner applicants further submits that since the applicants number 1.2 and 1.3 are were residing at Delhi, they were also not in touch with the present set of counsels, and it is only he submits that it is only on 22nd May 2025 when the present respondent started earth filling in the suit land. The present applicants came to meet the engaged counsel in Gauhati on 24/5/2025, and after coming to know about the dismissal of the appeal on getting abated, they requested their engaged counsel to take necessary steps for restoration of appeal on 25/5/2025. The learned counsel for the applicant submits that since the present applicants were not knowing regarding the dismissal of the dismissal of Putul. Itu bandhu. Dismissal of RSA 86/2011 till till 22nd May 2025. Hence, from the date of knowledge, only 72 days of delay has been there for in filing the application for setting aside abatement by the present applicants. Learned counsel for the applicant submits that there has been no laches or negligence on the part of the present petitioners or their engaged counsel in taking steps for filing application for setting aside abatement as well as for substitution of legal representative of deceased appellant in RSA 86/2011. Stop. On the other hand, Mr. U. Datta, the learned counsel for the respondent, has submitted that the applicants have failed to show any sufficient cause for condonation of delay, any sufficient cause which prevented them from filing the application for setting aside abatement within the prescribed period of limitation. He submits that the sole appellant had expired on 19/9/2021, and the application for setting aside abatement has been filed on 2/6
2/6/2025.
2/6/2025, and thereby total delay in filing of the application for setting aside abatement and substitution of legal heirs of the deceased appellant was of 1352 days. He submits that if from the aforesaid period, the period of 90 days for filing substitution application and period of 60 days for filing an application for setting aside abatement is deducted, and thereafter 90 more days are deducted in pursuant to the direction of the Apex Court in the case of recognizance for extension of limitation within bracket suo motu writ petition number 3 within bracket miscellaneous application number 21/2022 in suo motu writ petition number 3/2020. The total delay comes to 1113 days, which the applicants have failed to satisfactorily explain. He further submits that I'll dictate remaining part in chamber. today itself. For reasons mentioned in the judgment, this appeal is dismissed.
Item number 1, pertaining to promotional isol-based.
May it please your lordship.
Yes.
My lord, this is an application for enlargement of the.
No, Miss Linda, whether the
Yes,
diary has, the records have been received.
yes, my lord, we have received.
I say. Yes, yes, Mr. Powton.
My lord, so as per our perusal, my lord, the main contention in this case in the application is that the grounds of arrest has not been intimated either to the accused and or his relatives. So my lord, on that ground alone, the petitioner is entitled to be enlarged on bail, and my lord, his prolonged incarceration can be considered as an infringement of his fundamental right as well, given
Since
the
when you are behind the bars?
my lord.
Since when you are behind the bars?
My lord, I was arrested on 19/2/2023, and I was on interim bail on 3 occasions. Bail petition number 429 of 2024, wherein I was released for 2 months on interim bail. And on 25/2/2025, an interim bail was granted for a period of 3 months. And after that, 16/7, on 16/7/2025, an interim bail for 1 month has been granted again. So altogether, 6 months interim bail has been granted. And I have been incarcerated for around 2 years and 265 days, almost 3 years, my lord, as per my calculation.
Okay. Yes. Whether grounds of arrest? Yes, Miss Linda.
My lord, we are still checking. It's very bulky. However, my lord, the learned trial court has already considered the fact that he was arrested on February of 2023
No.
is
You
prior.
go through the records.
Yes, my
We'll
lord,
take
we are
it.
still checking.
Take it up after half an hour
My lord. My lord.
or tomorrow.
My lord, tomorrow also.
You go through whether section
lord,
48
the
notice is there or not.
48, the old version is there, my lord.
Whether it indicates that
Hmm.
that grounds of arrest were communicated or not.
My lord, this arrest was made prior to the judgment of the Supreme Court. So it's not applicable, the judgment which he has relied on.
Okay, that is one of your submission.
My lord, allow me, my lord. I will rely on 2 citations. That is 2024.
Yes, my lord.
We'll take it up after some time. You go through the records properly.
All right, my lord.
We'll take it up at 2:45.
My lord.
But I had filed an interlocutory application in connection with item number 41, my lord. Let me kindly be called for, my lord.
You have to give a mention. Memo.
I'll just.
Two 45 of isonomic. 44. Yes, what is this?
It is, Your Lordship.
Yes.
May it please, Your Lordship. Your Lordship, I filed an IA. I'm actually aggrieved by the order dated 9/12/2025, passed in IA Civil number 3618 of 25 in CRP IO 231 of 2025. I sought a modification on a very limited portion of the order.
What modification? Where is the order which you are seeking?
Order is at page 13 to 27 of my IA.
Page
13 to 27.
13.
And the affecting portion of that order is at para 18 of page number 23 and para 20 of page number 24.
Para 18 as well as para.
And para 20 at page 24. Para 18 at page number 23 and para 20 at page number 24.
How you are aggrieved?
Yes, Your Lordship, I have filed a divorce case against my wife. And there I have my allegation that the desertion was from her side. However, the para 18, if I may be allowed to read out, Your Lordship.
Yes.
In the instant case, the applicant, who is the mother of the Master Kairav Datta Medhi, has not been able to meet her elder son properly for almost 23 months, except for one occasion when such a visitation right was granted by the family court on 23/2025 for few hours. Your Lordship, in my reply to the IA and the CRP-IO, I have annexed documents which goes to prove that from the date of desertion, that is in the year 2024, December, I have been here in Gauhati for the matrimonial cases 11 times. And on each time I have brought my child, and the child had the right to meet his mother. This observation is going to cause prejudice to my case also, pending before the family court, Kamrup Metro.
No, this only depicts the fact which.
That facts have been disputed by me in my reply. And I have given documents. Those are part of record.
Okay.
That is number one. Number two is at page 24, para 20.
How it will affect you?
Your Lordship, during this period till 2025, 20th March 2025, numerous times the child has got the right to visit the mother. Numerous times, and I have annexed photographs of the same. When I was in
right
Gauhati,
to visit is a different thing. Whether he.
No, there was an IA in that CRP-IO where the visitation right was sought.
Okay. Okay, next objection.
Next objection is at para 20, page number 24. In the instance case, the separation of mother from her child was a consequence of matrimonial disputes between the parents. However, keeping the child away from the mother on one or the other pretext, and thereby denying him of his mother's love and affection, can never be regarded as a step in the best interest and welfare of the child.
Yes. Now what do you want?
Your Lordship,
How I will decide this application without making certain observation?
It's an observation, Your Lordship.
These are observation. At best, we can say that this may not have any bearing.
Yes, that can protect me.
But Lordship,
Because
this is a fact,
No,
because
big-
this is why we had in our CRP, we have written from the 19th of, on the 19th of December.
What I am proposing, because otherwise also you have to prove these facts before the
Trial court. yeah.
trial
Trial
court in
Understood.
divorce proceeding.
But Lordship,
So
if you
you,
see your
instead
obligation-
of relay, you are seeking modification. This cannot be modified.
at least a protection can be given that this cannot be, because I am still awaiting my evidence to be filed.
That protection may perhaps be given, that these observations made in this order may not have bearing in the, while adjudicating the divorce suit.
Part of their prayer, Your Lordship.
It
They
is
have
because
not-
I am seeking
they have
divorce
not-
on the ground of desertion.
There is no prayer to that effect, Your Lordship.
No, we can modify the relief.
Your Lordship, got you, Lordship, I'm not denying that.
We are not
not saying
at the first, without even hearing you, the prayer which he is seeking cannot be granted as it is.
Yes, Your
There
Lordship.
cannot be any modification. Though in this interlocutor application an observation may be made that the observations made while deciding the interim custody
Yes. The
application
visitation rights.
and deciding the visitation right may not have bearing in deciding the divorce case. The trial court will decide.
Lordship, bring to your notice, Your Lordship, ever since Your Lordship's order, actually we have got rights, visitation rights with the child. Understand, I've understood what you said, Your Lordship. The fact that the father still insists after your order, even then he is objecting to visitation, that also is on record, Your Lordship. And in that visitation, that was Your Lordship's order was passed on when was the order?
9/12/2020.
19/12/2025. In March, when we had put in a petition for visitation again, there was an objection from their side. And if Lordship would kindly go through Your Lordship's order dated 19th, at para 22, no, sorry, Your Lordship, at para 23, subclause 8, Lordship had given a direction that during the period of, Lordship, can I read? May I read?
Yes.
Number 8. During the period of 7 days when the child will be with the applicant, that is the mother, the probation officer district child protection officer Kamrup shall visit the residence of the applicant and thereafter submit a report as regards whether the minor's elder son of the applicant, so-and-so, is comfortable during his stay with his mother during the said period of 7 days. The said report shall be submitted before the learned principal judge, Family Court 3, Kamrup Metro, sorry. Lordship, that report never reached there, but consequently, when I went through the records of the High Court, that particular report is in the High Court records. They've sent it to the High Court, Your Lordship, which is part of the records of this case. Now, subsequently, Lordship, when we had put in the petition for visitation of the child in March before the Honorable Family Court, in their objection, the husband has said that he has written to the probation district child protection officer. There was no direction from the court for him to get in touch with the protection officer. And that is, if I may submit the petition that they have submitted, their objection, Your Lordship, a part of their petition which they have submitted there, that he has written to the protection officer. There's no direction from the court for him to get in touch with the protection officer. Why is he trying to influence the protection officer? This is what he is doing, Lordship. Whenever you get,
You complain, you put these matters to the notice of Family Court. Because now the matter is pending before the Family Court.
But report is not in the Family Court, Lordship. It's lying in the records over here, Your Lordship, High Court. This I will bring to the notice there, but the problem, Lordship, if we modify any order, based on your order, Your Lordship, I am getting some sort of visitation with my son.
We are not modifying anything.
You're just saying that is not going to cause any bearing. That's okay, Your Lordship. But
That will protect my interest.
his interest has been protected from before. He's thrown me out of the house, not allowing me to meet my elder son. I have not met my son for 2 years.
Now you are meeting or not?
Yes.
But again with objections, Your Lordship. Lot of objections,
Your
Lordship.
Lordship may allow me to submit. There was a specific direction that there was no need of filing any applications before the family court, because this order of your Lordship is sufficient enough to allow the child to go and visit during the vacation period of the school. They filed a petition, and there was an order passed by on 24/3/2026, if I may be allowed to, by the family court, where they have said that since there is an order of this Honorable High Court, there will be no further requirement of filing any application and passing any order on such application. However, on each vacation during school holidays, the child will have access, or the mother will have access to the child. And we are in
Now,
compliance.
whether it is happening or not.
Yes, it is happening.
May I
Recently
make
on 14th,
May I submit, Lordship?
That-
It is only happening because of your Lordship's order.
That will remain as it is.
Yes.
We are not altering.
Yes, Your Lordship. That is only happening because again, we had another holiday here
Recently on
recent
14th, he went back.
24th.
On 13th, he went back. to
Lordship,
Delhi.
my learned
Yes, yes.
friend is submitting as if man, it is so easy for the wife, mother to get access to the child. For 2 years, she got no access to him, in the sense he would bring him to court, meet in court, take the child back. So 2 years of complete brainwashing. Lordship has also met the couple in the chambers, Your
Yes.
Lordship, if you remember, Lordship. And
And the
even
same got
after that, Your
recorded.
Lordship, and also Your Lordship, after that, he's insisting that I'm paying maintenance. So one way she will come and drop, one way he will come and drop. Lordship, so it's making it very difficult for her because she is working. She's got another minor child with her who's living with her, and she's her old father. He's not paying, he's paying her a paltry sum of 30,000 rupees for herself and her little son. And he wants her to go with the little child and drop her and pick her up, pick him up, drop him, pick him up. He cannot come once, he cannot come twice. This is because we're getting access to him, but every step of the way he's giving us hindrances. It is very difficult for us to manage expenses. We've got 3 litigations.
No, all these things.
I understand totally.
I am not going to decide everything.
Yes.
Only the IA their if you concede, it will be easier for me to pass orders. Otherwise, I'll have to write a lengthy order.
It's all right, Lordship. I mean,
Only to the extent, without modifying his prayer is to modify. I'll reject his prayer, but make an observation that
That it will not affect me.
that it will not affect in your divorce proceedings.
that particular observation, yeah.
Yes.
Yes.
Only that the mother, the rest, not only that particular.
Observations made in
Para
para 18 and para 24.
Not
Because
just one. Can I just?
those observations are regarding fact. The fact he is disputing. He has right to dispute that before the trial court. Observations made in paragraph number 18 and 24.
Lordship, but if I may, Lordship, you've just written, in the instant case, the applicant, who is the mother of the so-and-so, has not been able to meet her minor elder son properly for almost 23 months, except for one occasion when such a visitation was granted by the family court on so-and-so days.
Yes.
There cannot be a dispute, but you have not, there cannot be a dispute regarding the proposition that the minor elder son of the parties, so-and-so, has the right to love and affection of both parents, and denial of the same would not be in the interest of the child. Lordship, what would the modification be required, Lordship?
No modification. Only observation that it will not affect you, I think. Heard Mr.
So
P.
Chaudhary.
Learned counsel for the petitioner, also Ms. Dr. N. Burwa, the learned counsel for the respondent. This interlocutory application has been filed by the applicant, namely Shri Rohit Datta Medhi, praying for modification of, under what provision you have filed this? What is the provision for modification? Praying for modification of order dated 12/12/2025. Order dated 9/12/2025. Passed by this court in the interlocutory application number, civil number 3618/2025.
Not 361. This is 4144.
In connection with CRPIO number.
Yes, 4144.
It is not 3618.
No, it is 4144 of 25.
Where is the impugn order?
At page 13.
Thirteen is 3618 only.
Your Honor, that is the order passed in 3618. My IA number is 4144.
No. I am not mentioning about your I number.
Apologies.
Manan Kelly. IO number 231/2025. The learned counsel for the applicant has submitted that the petitioner apprehends that since a divorce case is pending before the Principal Judge Family Court number 3, that is FC civil case number
Case number 25.
Yes, what is the number?
1307/2024.
The civil case number 1307/2024. And since the observations,
Lordship, this would be Miss G.
Miss G case.
Miss G case, Your Lordship. He has filed for custody also, so it is in the Miss G case, Your Lordship.
no, but your submissions where it will affect in,
It will affect both the cases, Your Honor, because my ground is same for divorce and for the custody also. Because she has
what is the divorce petition case number?
case number FC civil 1307 of 2020.
1307 of 2024. As well as a guardianship case.
Miss G case 192
bearing Miss G case number 192
of 2024.
2024. The learned the petitioner apprehends that since this court, while passing the order dated 9/12/2025 in IA Civil 3618/2025 had made certain observation regarding facts which the petitioner claims that he has disputed, it may hamper his chances in his chances of getting a favorable order in both the guardianship case as well as in the divorce case. He submits that he also apprehends that the observations made as regards certain facts in paragraph number 20 of the same order may also influence the trial court, since these observations are made by this court. On the other hand, learned counsel for the respondent submits that the observations made by this court in para 18 and 21 of the order dated 9/12/2025 were necessary for arriving at decision in the said IA interlocutory application, that is IA number 3618/2025, and same cannot be modified now as there is no basis for the same. Stop. She, however, concedes to a proposal. Don't fear word concede. She, however, concedes to a proposal given by this court that if an observation made in the to the effect that an observation may be made that the observations made in para 18 and 20 of the said order may not influence the trial court while deciding the guardianship case and the divorce case, and same shall be decided on their own merits. Stop. This court is also of the opinion that since the petitioner has not mentioned in the instant interlocutory application as to under what provision the said interlocutory application has been filed, it is liable to dismiss on that ground alone. However, further, it is also in agreement with the submissions made by learned counsel for the respondents that observations made in the order made in paragraph number 18 and 20 were necessary in arriving at a conclusion in the said order, and same cannot be modified now at this belated stage. Stop. Hence, the prayer for modification of the order dated 9/12/2025 is hereby rejected. However, for the ends of justice, an observation is made that the trial code, that is the family code number 3, before which the guardianship case and the divorce case between the parties are pending, shall not be influenced in any manner by the observations made in the order dated 9/12/2025, and the said cases shall be decided on their own merits. With above observation, this interlocutory application is.
Yes, Lordship, every time there's a holiday coming, where the court says, why are you giving petitions? But the parties are cannot talk to each other and get a visitation without us putting in a petition in the court election. And last time what happened was we gave a petition into the court, even though they said, okay, the court's order was shown to the court said, no, give a joint petition. Now, joint petition, Lordship, is every time we give a joint petition, when we put in a petition, it becomes a little difficult. So Lordship, can we give some observation that every holiday, both parties will, decide?
That is already there in the order of.
Prior to the impeding holiday or vacation, how both the parties, so then we can, then there's some sort of talking between the parties, because they're not talking to each other unless there's to the court order or some petition is.
Where is that? Directions of not of not.
Where's the direction? Direction that you.
That's in the order.
If your petition is.
24, 2000.
Yeah, 19, during pencil.
Where is that direction?
It was made by
This is the order of the
1950, yeah.
24, 2026.
No, we're talking about,
That's what.
Direction of not necessity of filing it.
we do not take a application every time.
That was made in this order, no, from the family code. See, the order, 2009,
24, 5.
24, 3, one copy. So, I count the paragraphs.
No, which order you required? There has.
There is an order copy of
Oh,
24.
that order is of family code.
Yes.
Unless that is put to challenge, I cannot pass. You may, if you point out any order passed by this court.
I get it.
Okay. So this interlocutory application is accordingly disposed of.
Problem is this visitation now, since the direction is gone from here, we're not being able to, we don't know where now, if we put a petition over
I
there.
understand.
So that's.
You come up with some
Yes, yes.
application.
I will. Apply.
Item 33 and 34.
May please your lordship. Lordship, my senior is on lake. He is in court number 10. The matter may be passed on for time being.
What is this?
Has been filed against the order of review.
My lord, if they file any objection, then a stipulated time may be framed and
You'll be filing objection.
For the first time, in earlier rounds, because of non-filing of review application, that complication has been arising in this case. The chance was not given for filing.
Now, what is this? Review application against which order?
against the I order, it was modified, my lord. Review was modified.
Not modified, correction was made.
Cost title was modified.
Review,
140,
order of review was
151
corrected.
converted to 152. So matter may be taken up after some
You,
time.
you file objection.
Yes, definitely, because in earlier, while the review order was passed, I was not given allowed the chance to filing objection, and that is why this complication has been arised. So definitely I will file objection.
Mr. What is your
But
name?
sufficient time.
Eke Hanan, my lord.
My client is 80 years old, is living in Hailakandi. He will have to come for deposing the affidavit.
My lord, immediately after vacation, then
Yes.
it may be fixed,
Yes.
and within that period, then
Mr. A.K. Hanan, learned counsel for the petitioner. Also heard Mr. S.K. Ghosh, learned counsel for the respondent. This application under Order 47 Rule 1 has been filed by the petitioner for review of the order dated 4/5/2026, passed by this court in IA number 1726/2026 in connection with review application number. Proof. Review application was renomenclated in earlier case.
Case review was allowed in work. Then there was some clerical mistake. Then
Review-
I have come up with an application for correction of that mistake.
But you filed a review application.
It was accidental mistake, not clerical.
But you filed a review application instead of an interlocutor.
That's converted into.
Okay,
151.
okay. Yeah, like, within bracket, review petition number 259/2025. Mr. S.K. Ghosh, the learned counsel for the respondent, praised for time for filing an objection against the instant review petition. The prayer is allowed. Let this matter be listed when? 29 July.
There's an application for condonation of delay, Miller.
It was file our objection, Lordship.
Written objection. Let them file. Condonation for delay for?
Miller, in the file restitution application, Miller, because the suit was dismissed for default, Miller.
Okay, heard Mr. M. Datta, learned senior counsel, assisted by Mr.
Islam.
M. Islam, learned counsel for the applicant. Also heard Mr.
Yayu Ahmed,
A.U. Ahmed, learned counsel for the
sole respondent.
sole respondent, who praised for allowing the respondent to file written objection against the instant petition interlocutory application. The prayer is allowed. Let this matter be listed. 29 July.
Diploma.
May I please, Your Lordship? Your Lordship, this I is for correction of cause title to incorporate the correct address of respondent number 5.1 to 5.3, Lordship.
Any objection? Heard Miss
B. Hajorika.
B. Hajori. D. Hajorika.
B. B.
B. Hajorika.
It's B, Lordship.
Yes, I am also saying B. B for Bombay.
Yes, Lordship.
B. Hajorika, learned counsel for the
Appellant.
applicant/appellant. Also heard Mr.
P. Daimari on behalf of PK Deka.
P. Doimari appearing on behalf of Mr. P.K. Daka. This interlocutory application has been filed by the applicant/appellant for correction of the
Cause title.
cause title of memo of appeal.
Yes, yes, Lordship. Yes.
Cause title of memo of appeal in connected RSA number 24/2023. Praying for allowing the appellant to incorporate the correct addresses of respondent number 5.1 to 5.3. The prayer is not objected to by the learned counsel for the other side. Hence, the same is allowed. The applicant shall file the corrected cause title on or before the next date fixed. Let this matter be listed. Let next day, no. File the corrected amended title, cause title, within 2 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Okay.
After 2 weeks.
My lord, here we have filed an IA for early hearing, but office note really reflects the records has not come. So may I pray that a reminder be sent after that I press the IA.
For what?
Early hearing.
Or records have not come.
Come from Kamrup.
Main appeal. RS. Heard Miss P. Bhattacharya, the learned counsel in appeal likhibo, learned counsel for the appellant. Also heard Mr. B. D. Deka, learned counsel for respondent number 1. Service of notice is also not complete.
Respondent number 3.
Also, Heard Mr. S. Bora appearing for respondent number 3. Who is appearing for respondent number 2B?
2B were appellants in a connected appeal, no, that appeal has been disposed.
But I think 1 and 2 complete, but regarding 3, I have, perhaps it is not complete. 2, 3.
3 is appearing.
No, 2, 3.
2 Roman 3.
Roman 3.
2 Roman 3.
Bahira na,
2C.
2C means.
2B or 2C?
Okay. 2C, yes, Lordship, 2C.
What will you do? As regards 2C,
Yes.
what you propose?
Perhaps service is awaited, Lordship, 2C.
2C is duly served. 2B is only services remaining.
2B, yes, he is residing at United Kingdom, Lordship. I have taken steps, Lordship.
2B.
Yes.
How you have taken steps? By what manner?
Lordship, I think split post that was sent, Lordship, earlier.
You take fresh steps.
Yes.
Stop. Last line killing. It appears from record. It appears from the office note dated 25/9/2025 that the notices issued to respondent number 2B has not yet returned, whereas the notices issued to respondent number 2A and 2C are duly served. The appellant is directed to take fresh steps for issuance of notice upon respondent number 2C,
2B.
2B by speed post within 7 days from the date of this order, returnable on 10th of August. The registry is also directed to issue reminder for records of the
Suit 164 of 2007.
records of title suit number 164 of
2007.
2007 as well as title appeal number
10 of 2016, 15 and 15 of 2016.
10 of 2016 and title appeal number 50 of
15, 16. 15 of 16.
15 of 2016 from the concerned court. Let this matter be listed again. 10th of August. This interlocutory application we will
I'll proceed on the
keep pending.
after service.
We'll take after service. We'll not pass any order.
Let it remain. Obliged. Item 38.
Yes.
We have filed, my lord, application for substitution, my lord, of legal errors of applicant number 4. And there's a delay, my lord. We have filed application for condition of delays. Petition number IA number 1416.
Delays of 3,000.
Lost.
Heard Mr. R. Ali Leonard, counsel for the applicant. This interlocutory application has been filed for condoning the delay of 3,534 days in filing the application for setting aside abatement and substitution of legal heirs of Appellant number 4. Issue notice to the respondents. The applicant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days of the date of this order, returnable on 5th of August.
Item 1 pertaining to idle bench.
Yes, have you gone through the records?
My lord, this is the arrest memo of the appellant, applicant, my lord. It's written here, the accused, after being informed of the grounds of arrest and his legal rights, was taken to custody.
Whether notice under section 48 is there?
It's not there. This incident happened in 2023, February. This is prior to the judgment of Vihan Kumar and the others.
Okay.
And my lord, in the same case, my lord, similar case was disposed of by the Honorable Division Bench of the Gauhati High Court, wherein the bail application was rejected.
What is the citation?
My lord, I have not given a citation. My lord, its case number is Criminal Appeal 67 of 2026.
And the order dated?
Order dated 21 April 2026.
Of the Aizol bench?
No, my lord. This is the division bench of the Gauhati High Court.
Principal seat?
Yes, principal seat, my lord.
Okay.
Sri Binandan Dahotia versus NIA, National Investigation Agency.
What has been held?
My lord, this has been held that since there was substantial compliance, the non-furnishing of the grounds of arrest in writing in 2019 cannot be a ground for granting bail to the appellants.
Okay.
I'm sorry, my lord, I have not given a copy of this to the...
No, we'll get it here. Okay, I'll go through the records.
Yes, my lord.
Mr. Pautu, you have anything to submit in reply?
Yes, my lord, though the submission of the TP would stand at this stage, but my lord, there was one observation in the coordinate bench of this court, wherein an arrest that was made on 13/8/2023 was granted bail, given the observation on the grounds of non-furnishing of the grounds of arrest, and that is bail application number 5 of 2026. That order dated 5/3/2026.
5/3/2026.
Yes, my lord. Here, the bench had made the observation
Of
that
which bench?
the Aizol bench, my lord.
Aizol bench.
Yes. Here, my lord, a reference was made to Kanish Sinha and another versus the state of West Bengal, 2025 Supreme SC 411, wherein it was stated that judgments of the courts of record would be retrospective. And my lord, communication of grounds of arrest. An oral communication has always been dissented in Prabir Purkayasta versus state my lord, at para 24, the constitution bench observation has been highlighted, has been emphasized, wherein the mandate of Article 22 of the Constitution of India requires that the grounds of his detention should be made available to the detainee as soon as may be, and that the earliest opportunity of making a
Okay.
representation.
Okay, I'll go through the records.
My lord.
All right, madam.
Heard Mr. Lalrungokung about to learned counsel for the petitioner. Also heard Miss Linda L. Farmville, learned public prosecutor. Let this matter be fixed for delivery of orders on 24th June. 24th. Right.
For June.
I'm obliged. May I please? Listen, this IA lordship, let me take up the IA lordship. We have filed this IA for amendment of the civil revision petition lordship.
Amendment of pleadings.
As pleadings is there lordship, and basically lordship, the order which we are challenging, lordship, may just come to page paragraph 4. Railway Tribunal lordship awarded 8 lakhs rupees in favor of the petitioner lordship as compensation, and out of that 7 lakhs was kept in FDR lordship. So we filed a petition there for releasing 50% of the that awarded amount lordship, and that petition was dismissed by lordship by order dated 7/3/25. Here, although we have mentioned both the orders in the cost title lordship, but basically in the prior portion we have not mentioned about that 7/3 order. So when the case was come up for hearing in the lordship may come to the order of this court lordship at page 19, page 7 lordship. So we sought leave from this court to file the amendment petition. Basically, we want to challenge that order lordship. And the amendment we are praying in proposed amendment lordship will find at paragraph 5 of the petition. In 2
Yeah.
paragraphs.
Yes, you have any objection? Total civil division petition. 53. What you are seeking, which para you are seeking to amend?
Paragraph in the fourth paragraph lordship. You want to just add that line lordship.
Where?
At the end lordship. I have mentioned in paragraph 5 of my this IA lordship.
This CRPIO is not yet registered.
It's registered lordship. It came up for motion also.
Okay. Heard Mr. M. Ahmed, learned counsel for the applicant. Also heard Miss A.
A Jain on behalf of B Dick.
A. Day.
A Jain,
Okay, A. Jain.
behalf of B Dick.
Appearing on behalf of Mr.
B Dick.
B. Decker, learned Central Government Council. This interlocutory application has been filed by the applicant praying for amendment of the civil division petition filed by the present applicants in CRP number 53/2016. 2026. The prayer is not objected to by the learned counsel for the respondent side. Hence, same is allowed. The amendment sought to be the petitioner is directed to file the amended revision petition within 2 weeks from the date of this order.
So you will file it by this week only.
Within a week from the date of this order. This interlocutory application is accordingly disposed of.
Okay.
Yes.
Chief, I'm so sorry. Lordship, with reference to item number 32, the report which has come from the protection officer, could Lordship kindly give a direction to send the report to the family court, please, Your Lordship?
Okay.
If it is possible.
That report is where it is.
In your order, Your Lordship, in your order dated 19th, you had,
Order Kunil Vasil
take a look.
Yes. What was the direction?
The direction was during the period of 7 days.
Record
the
sound.
child,
Putul record.
paragraph may I read, Lordship?
Where?
Paragraph 23 of your judgment, Your Lordship. Of your order.
Yes.
Order dated 19/12/2025.
Para?
There are 23, subclause 8, Your Lordship. During the period,
Stop. The learned counsel for the respondent has also pointed out that though by the order dated 19/12/2025 passed in IA civil number 3618/2025, a direction was given to the protection officer, child district, to the probation officer cum district child protection officer, Kamrup Metro, to submit a report after visiting the residence of applicant. However, to submit a report directly to the Principal Judge Family Court number 3, Kamrup Metro. However, learned counsel for the petition respondent submits that instead of sending the said report to the Principal Judge Family Court number 3, same is sent to this court and same is tagged with the case record of CRPIO number 231/2025. She prays for directing the registry to send the said report to the Court of Learned Principal Judge Family Court number 3, Kamrup Metro. Stop. Registry shall do so. It shall send the report of probation officer. In date is there?
of the report, Lordship? I don't have the report, Lordship.
You have seen the records.
I saw the records, Your Lordship. It's there in the records.
Report of the probation officer, cum district child protection officer, Kamrup Metro, to the Principal Judge Family Court number 3, Kamrup Metro immediately.
Obliged.
Item 14.
None has appeared for the applicant on call. Let this matter be listed in the next week on a date to be fixed by registry.
May I please, Your Lordship?
Yes.
But in this case, Your Lordship, respondent number 2 died and his legal heirs were impleaded, Your Lordship, already. And there was a direction to submit the amended post title, Your Lordship. And we could not submit that, Your Lordship. I am extremely sorry, Your Lordship. We'll submit by tomorrow, Your Lordship. Your Lordship allows.
But Miss
SSGI, Your Lordship.
SSGA, learned counsel for the appellant. Oh, also Mr. G. Bhardwaj, learned counsel for respondent number 1. Learned counsel for the appellant submits that due to some difficulty, the amended cause title of the memo of appeal indicating the names and address of the newly substituted respondents could not be filed earlier, and she prays for some time for doing so. The prayer is allowed. The amended cause title shall be filed as directed by this court within a week from the date of this order. Let this matter be listed again. 17th.
There is an interim order in IA Civil 1425.
The interim order granted earlier in IA Civil 1245
1425.
1425
26.
26 shall continue till next day.
My lord, in IA 176 of 2026, there was a stay against the execution proceeding, Your Lordship. IA to the 176, my lord. But
There are two interim orders,
okay.
one's against stay and one's injunction is.
Both the interim orders granted earlier shall continue till next day.
I do.
May I please, Your Lordship? An appeal under section 100 of the Code of Civil Procedure, Lordship, challenge the order and judgment and decree dated 35/2025 passed by the learned civil judge senior division Gauhati, title appeal number 2 of 2025, Lordship, while dismissing the said title appeal by not interfering with the judgment and decree dated 31/12/2024, Lordship.
You were the defendant.
Yes, Lordship, I am the defendant.
Super.
Respondent filed as a plaintiff with the title suit for the civil judge senior division number
Suit
2 for declaration the right title interest of the plaintiff over the suit land and for delivery of khas position of the suit land in favor of the plaintiff, Lordship.
Okay. Suit was decreed and appeal was dismissed.
Yes, Lordship.
What is the substantial question of law?
Lordship, as per direction of this honorable court, Lordship, I have already submit another additional affidavit, Lordship. Page 62, Lordship.
Yes.
What happened, Lordship? The appellate court, due to wrong calculation, came to the conclusion that there is no question of devolution of any land of suit dark number 429 to the successor of the late Satyanarayan Sahu.
No, what it held?
Lordship,
Please.
the appellate court, due to wrong calculation, came to the conclusion that there is no question of devolution of any land of suit dark.
What wrong calculation?
Lordship, they have 10 lakhs remaining plot of land for 10 lakhs are already there, Lordship. Lordship, what happened, Lordship? The total land measuring 1 bigha 11 lakhs and got acquired 1 kotha 4 lakhs.
sold 1 kotha 7 lesa. And as per respondent, 2 kotha 10 lesa. The remaining lordship 10 lesa also their lordship.
So what is the substantial question?
Whether the learned lower appellate court erred law in confirming the judgment of the trial court, which was passed without proper and measurement of or calculation, thus making the finding reserved and the decree unexecutable. And second is lordship, whether the lower court failed to exercise jurisdiction correctly by failing to order a survey or measurement such as
No. Second one is not substantial question. No, whether any execution case has been filed.
already filed lordship.
How much is the suit land?
Lordship,
How much is the suit land? What is the area of this?
area of land lordship, as per his land lordship 2 kotha 10 lesa, and remaining 10 lesa only missing lordship. Another 10 lesa is there lordship.
How much you are possessing? How much you are possessing?
Entire plot of land.
Entire means 2
Entire
kata 10.
lordship 2 kotha 10 lesa.
Now where is the wrong calculation?
No, lordship, 2 kotha total I have position 3 kotha. And 2 kotha 10 lesa as per respondent claim for the declaration of right title interest. And 10 lesa is there.
So are you claiming possession and right over 10 lechas only?
In the decree, 10 lesa is missing also. They have not mentioned any learned court had not.
No, you are not clear what you want to say. Suit was for declaration of right title in interest and recovery of possession.
Yes, Lord.
In respect of 2 kothas 10 lechas of land.
Yes, Lord, sir.
That was decreed.
Yes, Lord.
And you preferred an appeal. Appeal was dismissed.
Yes, Lord.
My query is, on what ground you are saying that the lower court erred? What mistake has, or what substantial question of law is involved?
Page 54 and 55, Lord, sir. 54 last paragraph, Lord. Thus, it is seen that after the sale of 2 kotha 10 lesa land by Satyanand Sahu to the plaintiff, he, Satyanand Sahu, was left.
Who is Satyanand Sahu?
Page 54, Lord, sir.
Yes.
Last paragraph, Lord, sir. Thus, it is seen that after the sale of 2 kotha 10 lesa land by Satyanand Sahu to the.
Who is Satyanarayan Sahu?
Our father, Lord, sir.
Your predecessor in India. Okay.
He, Satyanand Sahu, was left with no more land in Sudak for 29. As such, there is no question of devolution of any land of Sudak number 429 of the successor left Satyanand Sahu. In other words, to the defendants.
What is your stand? How much land
Lordship,
this does?
Lordship, there have Lordship 1 bigha 11 lesa. Total 111 lesa, Lordship.
In 429.
Total lot of land, Lordship. And Gulf equate 1 kotha 4 lesa. It is 24 lesa already Gulf equate, Lordship. And sold 1 kotha 7 lesa to Nores Agola and Suez Agola.
Thereafter, how much remains?
Lordship, and thereafter, Lordship, 3 kotha is there, Lordship. And respondent number claim for a plot of land 2 kotha 10 lesa. And 10 lesa is missing, Lordship, in the judgment, Lordship.
No, it may be missing. How it helps you?
Lordship, if the execution is done, Lordship, I have evicted by the respondent. Without demarcation.
Mr. What is your name? What is your name?
Gigi Gogoi.
Third, Mr. G.G. Gogoi, the learned counsel for the appellant. This appeal under Section 100 of the Code of Civil Procedure 1908 has been filed by the appellant impugning the which judgment you are impugning? Your title appeal, cause title is defective.
Lordship, judgment ordered at 35/2025, Lordship.
You correct the cause title. Why have you not mentioned?
Sorry, Lordship.
Not sorry. You rectify it. No, rules required. Gigi Gogoi, who prays some time for filing rectified cause title in the connected memo, in the instant memo of, in the memo of appeal of the instant regular second appeal. The prayer is allowed. When will you file?
Within 1 week, Lordship.
Let this matter be listed after a week again.
Wait, please, Your Lordship. We have filed the second appeal challenging the first appellate judgment passed by learned civil judge Nalwari in title appeal 8 of 2022, Lordship. Before going into the memo, Lordship, I just like to draw kind attention some basic facts. At page 28, Lordship, may I draw kind attention, Lordship.
Yes.
Para 2, it is in vernacular. আরজির তফসিল বর্ণিত জমিখণ্ড নলবাড়ী জেলার অন্তর্গত দিস এন্ড দিস 257 নম্বর দাগ ইজ ইম্পর্টেন্ট হিয়ার 1 বিঘা 4 কঠা 2 লেসার শরিকর অংশ বাদে 3 কঠা 15 লেসা জমি. This is one part, Lordship.
Page.
They have plaintiff, we are the defendants. Plaintiff have purchased 3 kata 15 lesas of land. Page 28.
Which para?
2.
Yes.
Next plot tip. At page 30, they have given how the title devolved upon. Page 30, they have given a chart here. The original land 257 belongs to 2 owners, Janak and Dhandolu. From Janak, it goes 3 sons. And out of the 3, they have got 6 legal heirs. Out of 6, they got purchased the land from 5 only, 15 lesser each. Next, Lordship, at page 33, that is the schedule of the price. At page 33. Only there is one schedule only. গাঁৱৰ 90 নম্বৰ পট্টা 257 নম্বৰ দাগৰ 1 বিঘা 4 কঠা 2 লেসা জমিৰ কাট 3 কঠা 15 লেসা বিবাদীয় জমি হয়. They have given one boundary and below that they have given one drawing. That boundary and drawing have never matched. It could not be understand how these 4 boundaries will match with this drawing.
Which is the scheduled land in the map?
Lots. It could not be understood what is the scheduled land here from their plaint itself. Our case is that we have also purchased from the same dak 3 kata 7 lesage, and we are possessing since 1990. The plaintiff come up with this plaint without any prayer of partition, simply right title declaration and for eviction against us. Trial court has passed the decree that was confirmed by the first appellate court. At page 62 of the first trial court judgment, Lordship, may I draw your pen? Page 62.
Yes.
At para 20, in the last part, Exhibit B is a certified copy of Jamabandi of the Patta number 90 of this village. Perusal of exhibit shows that by the order dated 9/2/1994, the name of the Maloram Borman, my predecessors, dependents predecessor, was mutated for a land measuring 1 biga 3 kata of dag number 155, 3 biga 4 kata of 159, 3 kata 7 less of dag 257. This dag 257 is in dispute, Lordship. Trial court has passed the decree against me for eviction. Without ascertaining for partition.
You are claiming to have purchased how much land in Dag?
We have total purchased 3 kata 7 lesage in
entire
this
land.
Dag.
Entire land in this Dag.
No. Out of 1 biga 4 kata, we have purchased 3 kata 7 lesage. So we have also shared in that particular Dag. So without any prayer of partition from the plaintiff side, Learned Trial Court has passed the decree for eviction. So
Where is your substantial?
at page 10, Lordship. Another mistake committed by the Learned First Appellate Court. 6 issues were framed. Learned Trial Court has decided on only 4 issues. No discussion or no decision was made on issue number 1 and issue number 6, Lordship. That's why I have formulated one question, Lordship, here. Whether the Learned First Appellate Court can decide a first appeal without making any discussion on the issues framed, without making any decision, issue number 1 and issue number 6. No discussion. Not a single whisper has been made. Simple, decided 2 to 5.
No, is it a substantial question?
Next, I am coming, Lordship.
Yes.
Because 41, 30, they have to mandate. First Appellate Court being the first court of facts, have to decide all the issues independently.
Points for determination.
Point for determination. That is one part. Second part is all the questions have to be determined. These 2 issues never touched. 1 and 6 has never been touched. No decision, either approval or denial. Second substantial case is whether
these 2 issues were framed by the
trial court. Yes,
trial court.
Trial court.
The appellate court has to formulate points for determination.
Apart from that, Lordship, trial court has to decide all the issues.
Yes.
As a under 4133, they have the power to change, modify.
Yes.
But trial court has to decide all the issues. Trial court cannot skip any issue.
Yes.
May concur or may not concur.
But you are challenging not the trial court's order.
The trial court has decided. First Appellate Court has not decided these 2 issues.
First Appellate Court. What is order 41 rule?
Order 41.
31.
Order 41, Rule 33. Rule 31.
31.
May I read?
Yes.
The judgment of the appellate court shall be in writing and shall state the points for determination, the decision thereon, the reasons and decisions, whether the decree appeal. So being a first appellate court, they have to decide all the issues, maybe concurred, may not concur with.
No. It has to formulate points for determination separately.
Here the only point formulated is whether the decree is correct or not.
Yes.
So while arriving that decision, no independently other points formulated, Lordship. Second part of the substantial question, Lordship, here, which arise, whether a co-pattadar joint owner can transfer their share by selling a specific plot of land by giving 4 boundaries without ascertaining share of co-pattadars. and also without formal partition of the suit patta when the land belongs to several persons. Here, admittedly, it is a 1 bigha 4 kathha land of particular dag.
This may be a substantial question.
Second part, whether a decree for recovery of specific plot of land can be passed against co-pattadar without formal partition. And another aspect, Lordship, in this case, while deciding the appeal, learned First Appellate Court has modified the decree. It is appealed by me. No prayer has been made under 152 or 153.
Modified the decree in what manner?
This drawing, etc. The decree was drawn, passed against 6 persons, drawn against 4 persons only by the trial court. Decree has been modified by the First Appellate Court without any prayer from the respondent side.
Heard Mr. S.K. Poddar, the learned counsel for the appellants. This appeal under section 100 of the Code of Civil Procedure, read with order 42, rule 1 of the said code, has been filed by the appellants, impugning the judgment and decree dated 6/2/2026, passed by the Court of Learned Civil Judge Senior Division, Nalbari, in title appeal number 8/2022, whereby the appeal filed by the present appellants was dismissed, and the judgment and decree dated 12/5/2022, passed by the Court of Learned Munsif number 1 / Civil Judge Junior Division number 1, in title suit number 64/2016, has been affirmed. So, after considering the submissions made by learned counsel for the appellant, as well as after going through the materials on records, following substantial questions of law are formulated in this appeal. Number 1, whether a co-pattadar / joint owner can transfer his share by selling a specific plot of land giving 4 boundaries without there being any formal partition of the suit patta and without ascertaining the shares of individual co-pattadars when the land in question belongs to several persons. Number 2, whether the decree for recovery of specific plot of land can be passed against co-pattadar without there being a formal partition of the land of the co-pattadars. So, number 3, whether without any appeal from the plaintiff against the judgment and decree, whether, the First Appellate Court can, in an appeal filed by the defendant, modify the decree on its own motion in favor of the plaintiff. Issue notice to the
They have
respondent.
appeared in caveat, Lordship. They have filed the caveat already. Copy has been furnished to them. Today's name has also been shown. None appeared today. Sole respondent here. And they have filed the caveat and copy has already been served.
Learned counsel for the appellant submits that the sole respondent has already appeared in this case by filing a caveat, and their names and the name of the engaged counsel for the respondent / caveator is also reflected in the cause list. However, no one is present. Learned counsel for the appellant further submits that he has furnished a copy of memo of appeal along with annexures to the home
Already caveat, Lordship.
to the caveators. Stop. Let the records of the trial court as well as first appeal court be called for. Let this appeal be listed on 5th of August.
Lordship. I have a IA for stay of the decree. Lordship. They have filed an execution petition which is going on there.
Caveator is not present before the court.
Okay, it should be till next date. It could be stayed, Lordship, because stay is there on Lordship. I have got some Xerox copies, Lordship.
This interlocutory application. No, have you served the notice of?
It is also been served, Lordship.
Where is the?
Along with caveat, because the filing of the suit, we have to give everything to the caveat unless it was not registered, accepted, Lordship. So I was also listed today, Lordship. And they have full knowledge. On the last day it was listed but could not reach.
Where is the indication that the notice has been served to the caveator?
Otherwise, it is not accepted, Lordship, in the branch. Even when caveat is there in the even our cause list, Lordship, caveator, the word caveator has been used there, Lordship, in the cause list itself.
No, that is okay. Caveator should have been.
They have filed the caveat there. They should remain present here, Lordship, as the matter is listed today. So till next date it may be, Lordship. Then it may not be disposed today. It may be kept pending, Lordship.
Heard Mr. S.K. Poddar, learned counsel for the applicant. Though name of Mr. P. Upadhyay is reflected as engaged counsel for the caveator in the cause list. However, none has appeared for the caveator / respondent in this interlocutory application / connected appeal. Learned counsel for the applicant has submitted that the applicant has already furnished notice as well as furnished copies of instant interlocutory application along with memo of appeal and connected annexures for service upon the caveator. This application under Order 41 Rule 5 of when is the date fixed?
Next date Most probably, Lordship, July somewhere, 5 or 7, Lordship.
What
I'm
is the
just checking that.
status of
No,
execution?
that order was not here, Lordship. That order was not there, Lordship. They have filed another petition before modification of the decree before trial court that was rejected. Now they have moved the appellate court for modification of the decree again under 152.
So that is pending.
That pending now.
So
I have got just
the urgency is not there.
no, Lordship, trial court has going on the execution proceeding, Lordship. They have filed the appeal petition for amending the decree. No stay was granted, Lordship. Till next date, I may be protected, Lordship. Till next date only, then let them come.
This interlocutory application has been filed under Order 41 Rule 5 of the Code of Civil Procedure, praying for stay of execution of the impugned judgment and decree, stay of execution of the impugned decree dated 2/5/2022, passed in title suit number 64/2026 and affirmed by the decree dated 6/2/2026 in title appeal number 8/2022. Since none has appeared for cavator in spite of reflection of their name in the cause list, hence till next returnable date, the execution of the impugned judgment and decree shall remain stayed. List this matter again on 5th of August.
Obliged. Deeply obliged.
Lordship, the matter may be urgent for the day because my senior is out of station. So that date may be fixed.
Malaki, let this matter be listed on next Friday. Because on the other day also they took time. I came prepared. On Friday next.
Heard Mr. E.C. Sharma, Learned Senior Counsel, assisted by Mr. G. Bhardwaj, Learned Counsel for the appellant. Also heard Miss Asha praying for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. The prayer is allowed. Let this matter be listed. No.
Huh?
Next Friday.
Next Friday. 17. Huh? 17, huh?
Not
No, 19.
Next Friday. Kimat?
19.
19th June.
Mother, I filed 2 affidavit in this case, mother. This has already been tagged. It may be kept in record. 2 additional.
It is already there.
Yes.
Your Lordship,
I have challenged the judgment and decree passed in by the appellate court, Lakhipur.
Yes.
Basically, with the appellant, originally filed a title suit against the respondent defendant seeking specific performance of contract on the basis of an sale agreement as entered into in the year 2003. So it was an unregistered sale agreement. The defendant entered into a sale agreement to sell out his plot of land measuring 10 acres. And he took an advance amount of rupees 50,000, your lordship. And it was agreed upon that after partitioning of the suit land and getting mutation, he will procure sale permission from the competent authority. Thereafter, he will execute sale deed in my favor. And possession also was delivered to me at the time of entering into this sale agreement. But he did not come forward and execute the respective sale deed as agreed upon. On the other hand, as a basic fact I am just explaining and he did not come forward in terms of the sale agreement. And later we came to know that he's in charge of intending purchaser. And so at that juncture, we lodged a complaint before the circle officer that sale permission should not be given because there is a sale agreement. And in the year 2016, he tried to dispose from me. Thereafter, cause of action arose. Immediately, your lordship, we filed a title suit seeking specific performance of contract and for permanent injunction. And the trial court decreed the suit in our favor, directing the defendant to execute the sale deed. And in their written statement, they contested the suit by filing your lordship written statement along with counterclaim also. Their only allegation was this is a fraudulently prepared document, nothing. And they did not take any defense under this specific relief act except fraud. So
what relief was sought for in counterclaim?
For directing the plaintiff, their counterclaim, directing the plaintiff to hand over the possession only. That is, they did not even challenge the that validity of that sale agreement. And there, in their written statement, your lordship, as well as in the counterclaim, the allegation is fraudulently prepared document for fraud is actually, there is no specific, your lordship, allegation is made on the written statement, only false. So, your lordship, an initial burden, we discharge the initial burden as they raise the issue of forgery. So we, more than 9 witnesses we examined for the plaintiff. Even your lordship, the attesting witness were also appeared in the, for examination, they were cross-examined by the other side also, and they could not make
What happened in appellate court?
Appellate court set aside the judgment.
On what ground?
They affirmed, the appellate court affirmed the issue of law of limitation. The appellate court affirmed the issue of maintainability of both the suit and counterclaim, your lordship. And the regarding the cause of action also, the issue is upheld. But on three issues, the appellate court differed. So I have mentioned in my ground of appeal, this is a substantial, maybe a substantial question of law, your lordship.
These are not substantial question of law.
No, your lordship, I'm raising. So the appellate court made observation regarding, appellate court has made observation that since the agreement for sale was not a registered document, so it cannot be taken as an authenticated document. So there is a provision, your lordship, because if sale agreement, if it is not unregistered, though it is admissible as evidence, so may be taken into consideration. Kindly, your lordship, I have mentioned, and I have annexed the impugned judgment also. The appellate court has made some observation at page 29 of my appeal. It is not actually tenable in the eye of law, your lordship. Page number 2932.
Yes.
Just, it was a concluding statement, observation, situated thus, in the scale of preponderance of probability, it can be inferred that sale deed, I don't know, time and again, your lordship, the learned appellate court is averring sale deed, sale agreement. He is treating the sale agreement like a sale deed. So this is wrongly mentioned. This is not sale deed. It is a sale agreement. It can be inferred that sale deed, Exhibit 1, my agreement actually has not complied to the terms required by the law under Indian Registration Act and Indian Stamp Act 1899. Though this has not made the sale deed, again, say, the appellate court is repeating sale deed invalid, but it has created a room for suspicion in the execution of deed of sale. So this may be, your lordship, may be a substantial question of law, because section, your lordship, section 49 of the Indian Registration Act.
Yes.
Second provision is there, provided that an unregistered document affecting immovable property and required by this act or the Transfer of Property Act 1882 to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act. It is clearly, law is very much clear, your lordship.
Then how it becomes substantial question of law? If it is so clear, then how it is a substantial question?
But the appellate court has made wrong interpretation of the same law.
Wrong application of accepted law. Can it be regarded as a substantial question of law? Perversity may be there. Okay. Anything else?
Anything, your lordship? Issue number 5. Why deciding issue number 5? Issue number 5, whether the deed of sale agreement is a forced document. Since the very beginning, in the written statement, in the counterclaim, they have only made allegation that it is a fraudulently prepared document. What kind of forgery was committed, done, it is not mentioned in their written statement and counterclaim. So, burden, we discharge all initial burden regarding the execution of sale deed. All the attesting witnesses were appeared. And they did not any evidence, your lordship, to prove the fact that sale agreement is a forced document. But the learned appellate court below has
given a finding, given any specific finding that it was forced. Whether
no specific finding, has not given any specific. Your lordship, I want to draw attention in another fact. His signature while undertaking cross-examination, nowhere earlier they stated before the trial court that signature is not mine. Since very beginning, even
heard Mr. Yudas, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been preferred by the appellant Muhammad Noor Alam, impugning the judgment and decree dated 28/4/2026 passed by the Court of Learned Civil Justice Senior Division Lakhimpur, North Lakhimpur in title appeal number 25/2024, whereby the judgment and decree dated 26/9/2024 and 3/10/2024 respectively passed by the Court of Learned Civil Justice Junior Division number 1 in title suit number 23/2016 was set aside and reversed, and the plaintiff's suit was decreed. No, reverse. Appellate court, what it did,
Set aside my judgment.
and it is dismiss the plaintiff's suit.
At this some, your lordship, at the same time, did not decree the counterclaim also. Their counterclaim was also dismissed by the appellate court in appeal.
And also dismiss the counterclaim
Yes, lordship.
filed by the respondent. After considering the submissions made by learned counsel for the appellant, and after going through the materials on record, following substantial question of law is formulated in this appeal. Whether the appellate court was at fault, whether the appellate court had erred in passing the impugned judgment by holding that the sale agreement entered into between the present appellant and respondent was a forged document, and thereby setting aside the judgment and decree of the trial court. Any other?
Yes, your lordship.
Only this. Issue notice to the
Okay.
issue notice to the respondents. The appellant shall take steps for issuance of notice upon respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of August, list accordingly. I am taking a short break.
Most probably.
My lord, if it is possible.
Okay, we'll take it.
There's some urgency, my lord, execution is going on. So as last item, my lord.
After taking these hearing under order 41 rule 11, I will take
My
up.
lord, my case is also under 41.
Then it will reach.
My lord.
Item 17. May it please, your lordship. My lord, we were the defendants in the original suit, my lord. Page 10, your lordship finds the plaint, my lord. I'll just indicate the dispute is very small, man. In fact,
Yes.
the plaintiffs had filed the suit claiming that they are descendants of daughters of one Kameshwar Medhi. Now Kameshwar Medhi, they admittedly was our father defendant, but they claim that prior to marriage with our mother, Kameshwar Medhi had a first wife who had died, and the plaintiffs claim that they are daughters through the first wife. We had disputed that position, my lord. We said that Kameshwar Medhi had only married once, which is with our mother, and therefore they are not descendants or daughters of Kameshwar Medhi. So the moot issue was whether they were in fact daughters from the first wife of Kameshwar Medhi. Kameshwar Medhi happened to work in the forest department and later joined the bar. Now, my lord, insofar as
Later on, he joined the bar.
Yes.
Okay.
Now, my lord, two issues, my lord, where I am harping on are two aspects of perversity, my lord. What had happened, my lord, to substantiate, although the other documents were not sufficient, my lord, to substantiate that they are daughters of Kameshwar Medhi, my lord. My paternity, of course, is admitted, my lord. So far as the plaintiffs are concerned, to establish their paternity, my lord, they sought to produce a marriage agreement. Now, discussion on the marriage agreement, your lordship, first of the trial court, your lordship finds at page 59.
Yes. What is it?
Page 59, para 34 for a moment, my lord.
Yes.
That's exhibit 2, my lord. That is paragraph 34. In the case in hand, when we scrutinize the documents as proved by either side, most of them are found to be recently issued. That is, those are not issued during the lifetime of Kameshwar Medhi. These recent documents have been collected by parties in order to place them in the proceedings of the suit. Exhibit 2, the deed of marriage of Kameshwar, with Padma has no evidentiary value. X1 certificate issued by so-and-so does not have credibility as revealed from the evidence of PW6, Vipin Borman, as according to him, the source is so-and-so. Now, if I may take your lordship's attention to page 91, that's part of the appellate judgment, just to show how exhibit 2 was dealt with by the appellate court. So first, the trial judge says that this particular marriage agreement is not admissible. I'll not look into it. Now, how the appellate court deals with is at page 90.
What happened in
Trial, my lord, it was decreed. It was decreed on the basis of other evidence, which I'll take your lordship through, my lord. Now, page 91 for a moment, my lord, how exhibit 2 was dealt with by the first appellate court, my lord.
Yes.
Lord, exhibit 2, that's somewhere in the middle of para 18. Exhibit 2, which is a certified copy of a marriage agreement.
Yes.
Exhibit 2, which is a certified copy of a marriage agreement of PW1, Beauty Medhi, who happens to be the plaintiff, my lord, alias Damayanti Medhi and Narendra Nath Das, from whom plaintiff examined as PW3. It is seen that the parties are identified by Kameshwar Medhi, son of Vishwanath Medhi, and the name of the father of Beauty Medhi is written as Kameshwar Medhi, which was executed on 6/3/1996. Though this exhibit 2 does not have evidentiary value, but taking judicial notice of the same, it is clear that the plaintiff Beauty Medhi and Narendranath Das had registered marriage, and the father of Beauty Medhi is shown as Kameshwar Medhi. Now, this is a deed of agreement purportedly executed between husband and wife, where Kameshwar Medhi was shown to be the father of Beauty Medhi. So, the appellate court also endorses the reasoning that yes, this may not be admissible in evidence because there cannot be a contract of marriage insofar as Hindus are concerned, you know? But it says I will take judicial notice of it. Now, so first thing, my lord, to take judicial notice, my lord, it must sort of satisfy the requirements of 52 of the BSA, or which is pari materia with 50. A of the Evidence Act, my lord. So here the First Appellate Court takes judicial notice. So this is one aspect which I'm challenging in the second appeal, that this is perversity. If you hold the document to be inadmissible in evidence, then for the learned court to take judicial notice, it must satisfy the requirements of section 52 of the BSA, my lord. Now, moving on to the next part of it, my lord. Page 61, if your lordship now has, of the trial judgment. Now, my lord, the closest relative of Commissioner Medhi, who was alive and who had deposed as a witness, was his own brother, Avinash Medhi, as DW2.
Yes.
Now, Avinash Medhi clearly stated in his examination in chief that my brother had married just once, who happens to be the mother of the defendants. Now, this evidence was discarded, my lord. Page 61, the words somewhere in the middle, your lordship finds DW2. DW2 Avinash Chandra Medhi.
Yes.
DW2 Avinash Chandra Medhi, the elder brother of Commissioner Medhi, has also in his cross stated that he had no idea with regard to what Commissioner did in the intervening period from his date of joining in service in Shillong till his retirement at Borpeta Road. DW3 so-and-so Patgiri has been found to have deposed in the same manner. DW4 has stated that he had no knowledge if late Commissioner Medhi had married another person during his service lifetime at different places. These witnesses had nowhere stated anything to suggest that they would have definitely known had Commissioner married Padma. From the testimony of the various defendants' witnesses as to above, we do not find any strong evidence to negate evidence of PW7 with regard to Commissioner marrying Padma during his lifetime. Thus, I find that the plaintiff 1 and 2 are daughters of Commissioner Medhi, and this point, therefore, is decided in the affirmative. Now, page 95, my lord, is how DW2, because we are aware that as per section 50 of the Evidence Act, this is the most relevant evidence when it comes to opinion as regards relationship among parties. Now, page 95, my lord.
95.
5.
Yes.
This is how the appellate court deals with the evidence of DW2, the brother of the person concerned, Commissioner Medhi. Similarly, on going through the testimony of Avinash Chandra Medhi, who is elder brother of late Commissioner Medhi, in his cross-examination, admitted that he had no idea what Commissioner Medhi did in the intervening period from the date of his joining in service in Shillong till his retirement at Borpeta Road. Even DW2 Avinash Chandra Medhi and DW3 Gopesh Padgiri in their cross-examination admitted that they did not know what Commissioner did during his tenure or whether he had married during his service period. The defendant also adduced the evidence of one so-and-so DW4, who also in his cross-examination admitted that during the period of Commissioner Medhi's service in various places, he has no knowledge if Commissioner Medhi had married. So the evidence of the most vital witness, according to me, under section 50 of the Evidence Act was discarded on the ground that he doesn't know what his brother actually did in his various places of posting. Malad, I've annexed the cross-examination of the brother, Malad. If your lordship has page 42A, Malad, just to indicate the perversity. Malad.
Yes.
It's a short, Malad. Can I read the vernacular very quickly? Malad?
Yes.
মই এই গোচৰৰ মই মোকাবিলা বিবাদী হিচাপে আছো কিন্তু জবাব দিয়া নাই আমি ভাই ককাই তিনিজন ডাঙৰজন হলো মই নিজে মোৰ তলত সৰ্বেশ্বৰ মেধি আৰু স্বৰ্গীয় কামেশ্বৰ মেধি so he happens to be the eldest আমাৰ মাটিৰ ভাগ বটোৱাৰা অফিচিয়েলি হোৱা নাই সামাজিক হিচাপে নিজৰ অংশ খাই বৈ আছো বাদী দুজন ভাই হতৰ পিছত তেওঁলোকৰ সতি সন্তান নিজৰ মাটি খাই আছে মৃত কামেশ্বৰ this is important this is how it was interpreted
মৃত কামেশ্বৰ মেধি শ্বিলঙত প্ৰথমতে পোষ্টিং ফৰেষ্ট ডিপাৰ্টমেণ্টত আছে বৰপেটা ৰোডত ৰিটায়াৰ কৰিছিল মাজৰ দুখৰত ক'ত চাকৰি কৰিছিল নাজানো মাজৰ পিৰিয়ডটোৰ লেংথটো মনত নাই তেওঁ এইখিনি সময়ত ক'ত কি কৰিছিল নাজানো তেওঁৰ বিয়া কোন চনত হৈছিল মনত নাই মোৰ মৃত্যুৰ তাৰিখ মনত নাই প্ৰদৰ্শ এক্সখন মাৰ শ্ৰাদ্ধৰ নিমন্ত্ৰণ পত্ৰ হয় নে নহয় নাজানো পিছত কৈ পাহৰিছো নাও এইটো সত্য নহয় যে কামেশ্বৰ মেধিয়ে তেওঁ বিভিন্ন ঠাইত চাকৰি কৰা সময়ত পদ্মা মেধিক বিয়া কৰিছিল No, he's clearly denied that suggestion. Only thing he said, the trend of cross-examination is, do you know where he was posted all along? He says, I don't know where exactly he was posted during this time, what he was doing. Now, this has been interpreted to mean that DW2 doesn't even know if his brother had been marrying at different locations, my lord. So, only on...
Whereas he has specifically denied.
And that thing he specifically denied. That he must have married in other posts. Now, but the trial in the appellate court holds that he doesn't know, since he says, I do not know where all he was posted and what he was doing and the intervening period. So then you don't even know if your brother had married Padma Medhi. That's the interpretation. So wrong interpretation may also lead to perversity. On these two counts, I'm challenging the judgments.
Heard Mr. B.D. Decker, the learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been preferred by the appellant Srimati Chandrama Medidas alias Makon, impugning the judgment and decree dated 25/2/2026 passed by the Court of London District Judge Pathshala in title appeal number 2/2023, whereby it dismissed the appeal filed by the present appellant and affirmed the judgment and decree dated 39/2015 passed by the... Ultimately, what was decreed?
It was partition was dated.
Dated 39/2015 passed by the Court of London Civil Judge Senior Division Court entitled suit number 11/2010. After going through the materials available on record, as well as hearing learned counsel for the appellant, following substantial question of law is formulated in this appeal. Whether the judgment of the first appellate court is perverse in relying on Exhibit 2, in taking judicial notice of Exhibit 2, that is certified copy of marriage agreement between
the plaintiff and her husband.
Between Beauty Medhi, alias Damayanti Medhi, and Narendranath Das, even though it held that the said document was not admissible in evidence. However, it took not admissible in evidence. ये पढ़ दो तो एक बार. in violation of the provisions contained in Section 52 of Bharatiya Sakshi Adhiniyam 2023. Whether the First Appellate Court also committed perversity in not taking into consideration the evidence of the brother of the, whose brother Avinash?
Deceased, Kameshwar Medi.
Brother of the Kameshwar Medi, namely DW2 Avinash Chandra Medhi. Stop. Who was the closest alive relative of late Kameshwar Medhi? Issue notice to the respondent. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of August. District Court.
There's an IA for stay.
Stay of what?
Stay of execution of the decree. But
Partition.
It's a partition decree.
How it will be executed?
Well, look, they have called for a precept, that finds the operative portion and
It is a preliminary decree.
it's a preliminary decree and a precept is ordered to be sent to the collector for effecting the partition. Page 62.
Okay. Heard Mr. B.D. Deka, learned counsel for the applicant/appellant. This application under Order 41 Rule 5 of the Code of Civil Procedure has been filed by the applicant/appellant for stay of execution of the judgment and decree dated 25/2/2026 passed by the Court of Learned District Judge Bajali, Patshala in title appeal number 2/2023, which has been impugned by the present applicants in connected RSA number 73/2026. Stop. It appears that in the connected RSA, the notices are issued to the respondents, and substantial question of law has also been formulated after, and the appeal has been admitted. In the appeal admit the appeal. Appeal has been admitted. Issue notice to the opposite parties. The petitioner, the applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode. Within 7 days, returnable 7th of August. In the meanwhile, till next returnable date, the execution of the impugned judgment and decree shall remain stayed.
Complaint.
Till the next day.
May please.
Yes.
You see, this second appeal has arisen out of an order by which the learned trial court initially rejected my application file under Order 21 Rule 97 CPC in an education case. And against that, we file an appeal that was also rejected. And against that, we have approached this Honorable Court, Your Lordship.
Oh, where is the substantial question of?
Substantial question of law. Second page, third page, Your Lordship. The background, Your Lordship, may kindly I would like to inform this honorable court that the respondent number 2 to 3, 2 to 4, and the appellants are the joint owner of a plot of land, including there are various plot of land, but the disputed land is also the joint owner and the joint sharer of this appellants and the respondent number 2 to 4, your lordship. And what's happened, this respondent number 1, behind the back of me, they enter into an agreement for sale without partition of the land.
Okay.
Then the intending purchaser, he filed a suit for specific performance of contract without making me party, though I am in the possession, being one of the co-sharer. And he...
No. Where is the substantial question of law? You have not formulated.
I have formulated.
Where?
Proposed substantial question of law.
Which page?
Third page. No, very first, third page.
Third page of the memo. Memo for
Just before the cost title.
It has to be in the memo of appeal.
It was filed by the clerk, where they have annex. You lordship got it?
Okay, okay. Now,
the judgment they have obtained ex parte, your lordship, and I was not party to that suit, your lordship. When they came for execution and they came to my land to dispossess me on the extent of that ex parte order, then I filed an application before the trial court under
why you failed? Why your application was dismissed?
Rejected, your lordship.
Rejected, 2197 application.
That was rejected, your lordship may kindly see. The trial court itself has admitted that I am the co-owner of the plot of land, and also admitted that he does not have any exclusive right, the person who sold the land, and he did not turn up in the trial court. And in my application also, I made him party, he did not turn up. Then I filed an appeal where he did not turn up. The co-sharer, your lordship. Everything he allowed to go on. Your lordship may kindly see the trial court's order. Page 79. Page 79 is the trial court's order, your lordship. And page 84 is the relevant, your lordship.
Yes. No, what was held by the
Trial court, your lordship.
executing court?
Executing court. Executing
You
court.
filed an application under order 21-97.
That was rejected.
On what ground it was rejected?
On the ground that I could not establish my exclusive right in respect of the property. The question of exclusive right does not arise because I am the one of the co-sharer, co-owner. I am a joint owner, your lordship.
And what was held by the appellate court?
Appellate court, paragraph 1, page 106. From the above discussion, it transpired that the suit patta is admittedly joint property of the co-sharers. That means I myself, your lordship. Then there is a commission was issued, and the Amin commissioner also gave a report that I am in the possession. The Amin commissioner report, though prepared, did not conclusively establish as page 106, your lordship. The Amin commissioner report, though prepared, did not conclusively establish exclusive right of the appellants. Rather, it reflected possession aspects, your lordship. Possession has been admitted, and this land has not been partitioned as yet. On the extent of one of the co-owner of the land, I am possessing a part of land, and without making me party, they have entered into an agreement, and they came forward to execute the order, which was obtained ex parte, your lordship.
What agreement?
Agreement for sale in respect to unpartitioned land. The person who entered into the agreement claiming to be the exclusive owner and possessor of the land, but he is not the exclusive owner. He is one of the joint owner, your lordship. How he can give a specific boundary without having any partition, formal partition, your lordship?
Okay, heard, Mr. N. Sharma, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellants, impugning the judgment and order dated 11/3/2026 passed by the Court of Learned Additional District Judge FTC Kachar, Silchar in Miss Appeal number 12/2018, whereby it affirmed and upheld the order dated 27/8/2018 passed by the Court of Learned Civil Judge, Senior Division number 1, Kachar Silchar in Miss Case number 13/2007, arising out of Title Execution Case number 1/2005, whereby the application filed by the present appellant under Order 21, Rule 97, 99 and 99 of Code of Civil Procedure 1908 has been dismissed. After going through the materials available on record and after considering the submissions made by learned counsel for the appellant, following substantial question of law is formulated in this appeal. Whether the executing court and the first appellate court committed perversity in dismissing the application filed by the petitioner, filed by the appellant under Order 21, Rule 97/99 of the Code of Civil Procedure, without considering the fact that the present appellants were admittedly the joint owner of the decretal land, and there was no partition amongst the co-pattadar. Question mark. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode, by within 7 days from the date of this order, returnable on 10th of August. Let the records of the first appellate court, records of the executing court, as well as the first appellate court be called for list accordingly. You have an IA?
No, yeah.
You
Not
have
yet
an
filed. Not yet filed here. They have not disturbed till now, that is why I have not filed. Yeah, brother.
I'm taking a break. And decree passed by the Civil Judge Senior Division Dhubri. The judgment was affirmed. Judgment and decree passed by the Civil Judge Senior Division Dhubri in title suit number 15/2017 on 25/2024 was affirmed. After going through the materials on record, as well as after considering the submissions made by learned counsel for the appellant, following substantial questions of law are formulated. Following substantial question of law is formulated in this appeal. Whether the trial court as well as the first appellate court had committed perversity in holding that the suit line in title suit number 15/17 is same as the suit line in title suit number 34/2019, 1982. And whether both the courts below heard in decreeing the suit and affirming the same respectively. Stop, issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of August.
I leave this.
May it please the lordship. My lord, a decree was passed, my lord, in a suit where we are not party, but we are the pattadar of the land in question, my lord. Now what happened, my lord, when execution officers went there, my lord, then we came to know that there is an ex parte decree. We are not made party in the suit. Thereafter, we filed a petition under Order 21, my lord. And that petition was dismissed by the executing court, my lord. And after dismissal, my lord, we file an appeal, then appeal also dismissed, my lord. So, my lord, I am giving this judgment, my lord, at page 7 to 20, my lord. My lord, here, mainly, my lord, it was decided that we could not produce any document to claim our title. On that point only, my lord, that has been dismissed. So my humble submission before your lordship, as per Order 21, Rule 100, my lord, if a petition filed under this Order 21, my lord, it will be treated as a decree. So, my lord, suit is to be, that petition is to be tried as a suit. But the learned courts below, my lord, just pass an order without framing any issue, nothing of the sort. My lord, just it is said that you could not produce any document that you have a patta holder or your predecessor in interest was patta holder. So, my lord, to that extent, my lord, the suit is not properly tried. Number one, my lord, and number two is this, my lord. That person, my lord, who filed the suit, original suit, my lord, he could not produce any document that he is the pattadar. Because, my lord, land belonged to our predecessor in interest. Only thing is this, my lord, your lordship would be pleased to see page 64, my lord.
No. In Order 21 petition, you have to show that you have some right.
My lord. No, my lord, that is why, my lord, I want to show before your lordship one document, my lord.
Page,
Page, my lord, 65B.
there is no 65B.
Annexure 6, my lord. 62, me, well, sorry, 62B. That Wazuddin was the plaintiff, my lord. Wazuddin, where from Wazuddin, my lord? Your lordship would be pleased to turn to page 64B, my lord. 64B. Your lordship will see serial number Zomirat Uddin. So, well, the Zomirat Uddin would the original Patadar. He is the predecessor in interest of the appellant before your lordship. Muhammad Wazuddin, serial number 12, my lord. Serial number
We'll
12.
take up this matter tomorrow, first item.
My lord.
Tomorrow is first item.
Tomorrow. My lord, may I pray, my lord, that item number 41, my lord, in the hearing results. That may also be taken up tomorrow, my lord. Some urgency, my lord.
Thank you. Third, Mr. M.A. Sheikh, learned counsel for the appellant. The hearing under order 41 rule 11 could not be concluded, hence list this item as the first item under hearing under order 41 rule 11 tomorrow as part of matter. Yes, Mr. Chaudhary.
Item number 41 of your lordship daily list, my lord.
This hearing item,
Yes, ma'am. This may be taken up tomorrow, my lord. There is some urgency in the matter, my lord.
final hearing.
Final hearing, but today I have filed in, my lord, interlocutory application for injunction. What has happened, my lord? There is a finding on the last date, my lord, this proceeding has abated, my lord. Because, my lord,
Who is for the other side?
Mr. Chauhan appears, my lord, he is here. He was just here, my lord. I'll inform him, my lord, this matter will be taken up tomorrow, my lord. Because ultimately it will not be heard because already the proceeding has abated, but because of that, my lord, stay of the execution, my lord, by way of a miscase, that has not merged. So, my lord, that there is a, my lord, direction required to be passed by this court that, my lord, because just already there is a finding that it has abated. So, further proceeding will close and the order in the miscase will merge with this order so that
What has been evident? Appeal.
appeal.
That means the original decree and
Yes, it will revive.
that will revive.
It will revive, then I can execute it because there's a stay order. So I am not being able to execute it. And now what happens, this
But
appeal has,
it will be listed tomorrow subject to only you have to intimate the other side.
I'll intimate just now. He's outside only, my lord. He was here just 1 minute earlier, he was here. I'll intimate him just now.
This matter could not be listed due to paucity of time. List it tomorrow.
Item 49, can it be taken on Monday or Wednesday, my lord? Already execution proceeding has been initiated, my lord. That's
Item 49.
49, my lord.
49 Wednesday.
Much obliged.
Now, item number 48, this may be taken on 15th of July.
And item number 48. Paucity of time. List it on 15th of July.
Of like.
So item number 42, Lordship.
46. No, 46.
Oh, 46, sorry. Item number 46, Lordship.
46.
The matter actually should have been come under order column, Lordship. It has come under hearing, Lordship. The respondent number 4 service is not completed. We have taken several steps. 3 steps last we have taken, but services remain unserved, Lordship. Notices remain unserved. So we may be allowed to take alternative service course, Lordship, by.
No, we will list it in orders column, then we'll pass.
Lordship, one day, Lordship.
It is submitted at bar that this item number 40.
46, Lordship.
Heard Mr. A. Islam, learned counsel for the appellant. Also heard Mr. G. Bhardwaj appearing for respondent side. It is submitted at bar that this matter ought to have been listed in orders column. Accordingly, list it in orders column.
Monday, Lordship.
Next week at the date due. 22nd. 6.
Always.
23rd, okay.
May I please your losses? My lord, I get to mention item number 52. That may kindly be taken up next week, losses 23.
Hearing,
Hearing, my lord. Urgency is there. Right now.
who is for the other side?
I am the respondent's plaintiff losses.
Next week. Next week is a motion day, motion week. It has to immediately after reopening.
Fixing a date
List this matter.
on 16th of July,
23rd July.
23rd July.
Yes, Mr. Singh.
I have all prayer.
Be quick.
My lord, this matter we have, my lord, against the, my lord, execution proceeding, my lord. Today we came to know, my lord, that the Najir and, my lord, the officials of the court, my lord, went to the to my place to evict me, my lord. Whereas in a suit,
What do you want?
to, my lord, let it be listed tomorrow, my lord. Because, my lord.
Tomorrow it will be difficult because
Very urgent, my lord. Tomorrow, my lord, I will be evicted by police force and, my lord, JCB, etc. That I am told, my lord.
when have you filed?
My lord, I filed firstly, my lord, FAO against the order passed by the learned court below. That
Now what you want to get listed?
FAO was withdrawn, my lord, because of some
Then now
Now, my lord, we filed this today itself, my lord, after withdrawing FAO, and my lord, we pray to get it listed tomorrow, my lord.
okay, tomorrow.
I'm deeply obliged.